Item number 5 is 2010 matter, my lord. Dispute is regarding a boundary wall, my lord. My instruction is that possibly the neighbors have settled the issue. Can it be next week, my lord? Sir, I've taken consent from him, my lord. Next week, a fixed date may be given, my lord, by that.
Repeat Chakraborty pleaded counsel for the appellant submit that possibly the matter has been settled outside the court, and therefore he prays for a short accommodation to take instruction. Please this case on Tuesday next month.
May I please your lordship? But I beg to mention item number 9, lordship. My senior is admitted in hospital for
Mr. Chakraborty, Tuesday 15th. 15th is the holiday. On Wednesday 16th. Yeah, item number 9.
9, lordship.
Yes.
My senior is admitted in hospital for pacemaker implantation. lordship.
Okay, no problem.
Sometime required for his recovery.
Okay, in fact, the
After
other day,
six-
Let it be 12th September. ma'am.
Yes, lordship.
will not fix a date. Let it be after one month.
Yes, lord.
Madam, may I pay kindly?
No, you make
Madam.
a mention, see somebody is not well.
That is true, madam. Let
Let
it
us
be
have it
fixed.
after 4 weeks, you make a mention, will depends on the how.
We also appreciate. Only date, madam. It is very difficult to unless fixed.
You
date,
make a mention, what is the difficulty? 17 matter will list it.
madam.
Let him be okay first.
Madam.
Your colleague is not well.
That is true, madam. Let it be.
It is submitted that P. Mahanta Leonard counsel for the appellant is unwell and is in the hospital.
Yes.
List after 4 weeks.
Obliged.
May
Hello.
please, your lordship, today's partial list was item 59. Okay, this is the B. Goswami will be appearing in this case. So if possible, maybe taken up today after the completion of the daily list. lordship. 59, it's a appeal filed by the state against the money decree against us lawsuit. So because the interest is actually
Who's in the other side? Who's in the other side?
lordship, I'll inform them, lordship.
You have to inform them first.
Sir, I'll
You
inform them.
upgrade. First, you have to inform them.
I will inform the intercourse of the lordship.
Inform them, then we'll see if it's possible.
Lordship, yes. lordship.
May I please, your lordship, my lord, I beg to mention item number 16 to 21 of supplementary list, lordship. Lordship, I am for NCT lordship. Today I am going to file the affidavit, lordship. So kindly this matter may be taken up on 29th, lord.
Yes, who's there? You are.
They are item number 18, 20 and 21. madam. All other council already informed, lordship, by me.
You are in which matter? In
What?
some matters, Mr. Alam is also appearing.
Lordship, except two lordship, all are similar lordship out of same college, lord.
No, in which matter are you appearing?
You both are lordship representing NCT. lord. So.
Hmm.
Affidavit already received, lordship.
But your name is not being shown in the cause list.
But lordship, I am appearing lordship here. Because we both are lordship representing the NCT lordship as a standing council lordship. So no difference.
In
lord.
none of the cases. See,
So, lordship, in one case, perhaps lordship court, dishonorable court, lordship, make the NCT as a respondent. lord.
response to understanding council NCT submit that the affidavit in opposition would be filed during the course of the day,
Course open.
and therefore he prays for some accommodations for Sapara as agreed to by the parties based on
29th of August.
29th of August.
Yeah.
16 to
I will charge.
29 August.
Obliged.
My please, your lordship. My please, your lordship. I beg to mention for listing an IFO condemnation of delay, my lord. Other set already appeared. My lord, maybe taken up even tomorrow, my lord.
Not tomorrow,
My lord,
Friday.
my lord,
MSC April.
my lord.
You are
No, no, my lord, I miss no, my lord. LA, my lord, my lord, land, my lord, second appeal, my lord. Connected to second appeal. Yesterday I have moved, my lord, this another case, my lord. The demolition, my lord, already started. My
Oh.
lord, then Friday. Highly obliged, your lordship.
Please, Your Lordship, with the consent of the other side, I beg to mention item number 7 of today's daily list,
Yeah.
Lordship. I am for the respondent insurance company. I've taken the consent of the other side.
What do you need?
Lordship, after a week or 2 weeks, Lordship. 2 weeks.
Ms. Rosendar is not around.
No, Lordship. She has gone to Nagpur for meditation.
Okay. It is submitted that MS R.D. Mazumdar, Senate Counsel for the respondent, is out of station. And therefore, a prayer for adjournment has been made. So, para, considering that this matter is of the year 2013, list this matter on 16th.
Lordship. 16th, Lordship, actually, AK Podcaster sir said that he'll not be here next week.
13 matter,
Lordship,
and
yes.
18th,
Lordship,
18th. 18th.
18. 18 is a holiday, Lordship. 18th is a holiday.
18th is the holiday.
Yes, Lordship. It's something
They're on 21st.
21st, Lordship.
21st, don't know adjournment on 21st.
Yes, Lordship. Much obliged,
Yes.
Lordship.
May I submit, my lord, item number 13, may I sitting in adjournment, my lord, due to my senior physically.
Here for the appellant,
Yes, Aram Das.
and who have you informed the other side?
Yes,
Have you informed the other side?
yes, not my,
You have
No.
to inform the other side.
nobody's in, my lord, this is the unfortunately, my lord. My senior informed me and
You take the consent, then you make a mention, we'll allow the mention, but not without consent. You inform them and come, otherwise you have to wait till the matter reaches. We'll adjourn, but in presence of the other side. Yes,
obliged.
Me, please, your lordship. I beg to mention this MFA for hearing. There are 3 analogous matters. The last date of posting was 29/2022, and the service and records have already been received.
MFA
Services,
regarding what?
regarding workman compensation.
You are for the insurance.
I am for the claimant.
For the claimant. Okay, when do you want?
Thursday,
Appeals of which year?
2022.
You are mentioning for what purpose?
It
Orders?
is ready regarding service and records. So
We need to pick
for
one.
hearing,
No, not for hearing, you need to have it day after tomorrow for orders.
obliged.
Your lordship, the matter may kindly be passed over for the time being.
But we'll have it during the course of the.
Much obliged.
I beg your lordship, my lord, in this case, we preferred an this appeal, my lord, against the MP order 8, page 86, my lord, of 5/4/23, my lord. Here, my lord, we have filed a petition under order 8, rule 9. My lord, this was dismissed along with another petition, my lord. So against that, we have filed this appeal, my lord. Now, what happened in this case, my lord? Page 86, lord.
You are the plaintiff.
I am the plaintiff, my lord. I have filed a court for recovery of, my lord, 73.02 lakhs, my lord.
Suit for recovery.
Yes, my lord.
Money suit.
Money suit, lordship, in 2012, my lord. So there, my lord, the defendant has filed a written statement, my lord. And in the written statement, my lord, he is admitted the liability to the extent of 68 lakhs, my lord. And out of that, he has paid 10 lakhs also, my lord. And rest are to be paid by the installments, my lord. Some by 10 lakhs or 5 lakhs, so like this, my lord. So when the suit was situated thus, my lord, proceeding, then the suit was, my lord, dismissed, my lord, on 6/11/2013, lordship, for non-prosecution, my lord. So against that, we filed an application under order
6/11/2013.
6/11/2013, my lord. That is the
13.
first dismissal.
1-3.
1/3, my lord. That is the first dismissal. So, my lord, against that, my lord, we filed an application under order 8 rule 9 along with section 5, my lord, limitation, because there is a delay, my lord. We came
Order
to,
8 to 9.
my lord. Order 8 rule 9, my lord, of CPC, my lord, for restoration of the suit, my lord.
Order 8.
Order 9 rule 9, my
That
lord.
is
So,
it.
order 9 rule 9, sir. Lord. Order 9 rule 9, lordship.
Yes,
So, my lord, along with that petition under section 5 of the limitation act, my lord.
you filed 49 or 9 petition
Yes, my lord.
along with section 5.
All along with section 5, my lord.
Yes,
My lord, now, this petition was registered as Miss J case number 26 of 15, my lord.
Hmm.
And my lord, the condonation petition was registered as Miss J case number 27 of 15, my lord.
yes.
So, my lord, both the petition was allowed eventually. My lord, now against the condonation of delay, which was allowed by the trial court, my lord, the defendant moved before this honorable court by OFS CRP, my lord. That was dismissed.
Okay. So, here. Sorry, dependent.
That was dismissed, my lord.
Okay. Thereafter,
Thereafter, my lord, when that order 9 rule 9 application was allowed, against that, they have also filed another CRP, my lord. In that civil division petition, my lord, while admitting the civil division petition, the proceeding of the trial suit was kept in abeyance, my lord, and which was extended from time to time.
yes,
And since, my lord, that trial court has restored the suit, my lord, they take up the suit. But because of the stay order passed by this honorable court, my lord, they staying the proceedings, some order was passed, not effective order was passed, but extending the time, that's all, my lord. But unfortunately, my lord, when the situated does lordship on, my lord, আমাদের কবে হলো dismissal টা? আমি জানি। On, my lord, when then this petition was again dismissed for default, my lord. On
When was-
10/31/2020.
when was this stay order passed by the High Court?
My lord, Theodore passed a 3/1/2020 lordship. That I have stated in my petition, lordship will find.
Have you annexed the order?
Yes, my lord. Paragraph, my lord, 13. If your lordship paragraph, look into paragraph 13, page 6, my lord. I have detailed everything, my lord. The sequence. What happened after restoration of the suit, my lord.
Have you annexed that order?
Order, my lord, you have not annexed this, but I have stated, my lord, in paragraph 13.
This is a very crucial order.
Yes,
Should have annexed. Okay, thereafter what happened? You say that the High Court had stayed the proceeding
yes, my lord.
on 3/1/2020,
Yes, my lord.
and thereafter, no effective orders could have been passed,
Yes,
but their dates were given from time to time.
my lord, my lord.
Till when did the stay order was effective?
The order was vacated.
CRP is still there.
Normally, it is being disposed of by remanding the matter to decide before the trial court decide the matter afresh.
When?
It is on 2020, my lord. That order, my lord, will find. Hmm? Page? Huh? 59, lordship.
5/9.
59, lordship. Done. Page 59, lordship.
Hmm.
Now,
16/7.
yes, my lord. Now 62, lordship will find the order, interim order passed earliest and vacated, my lord.
Okay, thereafter,
Thereafter, my lord, when matter was just proceeding, my lord, but no effective order because of this stay, my lord. One day I could not, advocate for the plaintiff could not appear and the suit was again dismissed, my lord.
When was it dismissed?
That was dismissed on 31/1/2020, my lord.
31,
1/2020,
20,
2020, my lord.
when the High Court case was still pending.
Yes, my lord, because of this COVID and all this, my lord, everything came to stand still, my lord. Matter could not be taken up. So against the order, my lord, we
So
again
taken dismissed for default.
dismissed for default, lordship. Against that, my lord, we filed a civil division petition before this honorable court, my lord, which was withdrawn, my lord.
Yes.
Because the court, honorable court say file a petition under order 9 rule 9 before the trial court. So accordingly, my lord, withdrawn the petition and file another petition under order 9 rule 9 before the trial court, my lord. And that, my lord, will find at page 66, my lord.
Sixty,
66 also. That is our miss case was 36 of 2022, my lord. Page 66, my lord. That is the miss. Under order 9, rule 9. CPC.
correct?
Then, my lord, both the petition was taken together and impugn order passed at page 86, my lord.
Which both petitions,
Yes, my lord.
which both
My
means?
lord, both that, my lord, the petition which was remanded by this honorable court, that earlier, my lord, order 9 rule 9 petition was allowed by the trial court. Against that, they filed a CRP, civil devotion petition. The CRP was allowed and remanded the matter. That order, my lord, will, by pursuance of that order, my lord, both the petition was taken up by the trial court, my lord.
Okay. Trial court was on the remand order was to reconsider the earlier application. for
Yes, my,
restoration,
yes,
As well as your
Ah.
subsequent application under order 9 rule 9
Nine.
for restoration.
So both
Okay.
the petition was taken up, my lord.
Okay, okay. Thereafter,
And the impugn order was passed at page, my lord, 86, my lord. Start from 86, my lord.
86,
86, my lord. Annex 9, lord.
Mector,
Annex my lord, N, page 86.
5-4.
5/4/2023, my lord.
Yes.
May I read, lordship?
Please.
Petitioner and the opposite parties are represented by the learned counsel. Today is the fixed for the order on the petition 240 of 2022 filed by the petitioner plaintiff under order 9 rule 9 CPC read with section 151 for restoration of the suit. The petitioner, the plaintiff filed money suit against the opposite party defendant for recovery of the money. Petitioner engaged advocate D. Sinath and practicing lawyer of the Bangaigaon and Abhayapuri who thereafter engaged one junior to assist him in the suit at Borpeta. The opposite party appeared in the suit as defendant and filed written statement admitting the liability to pay rupees 68 lakhs only. It is the contention of the petitioner plaintiff that he was maintaining constant touch with the advocate D. Sinath and was acting as per his advice. Advocate D. Sinath assured the petitioner plaintiff that he will look after the suit with care and responsibility by attending before the learned trial court as and when fixed. Petitioner also visited the chamber of the advocate D. Sinath and paid fees to him and also for his junior. Petitioner last met the advocate D. Sinath on 29/7/2023 at Borpeta Bar Association. On the same day,
Come to the operative part.
my lord, now operative part lordship will find. Now lordship will operative part will lordship will find from start from my lord page 89, my lord.
But this observation at page 97,
My lord,
the remand by the High Court
Yes,
was
ma'am.
on 14/7/2020,
Yes, ma'am.
and you had filed your order 9, rule 9 only on 10/3/2022.
2022, my lord. Well, after this COVID, this was over, my lord, because there's
No, nonetheless, at page 97, come to 97,
Yes, my lord.
top portion.
Honorable High Court also passed an order on in the
CRP?
CRP on 60 of 2020. By order dated 4/7/2020.
14/7.
14/7.
Thereafter, to approach this court to file.
Petition under order 9 rule 9.
Yeah.
Before this court. However, this petition could file only on 10/3/2020, my lord. Then, my lord,
22.
22, my lord. But from my lord 1/3/20, my lord, lordship is aware that COVID-19, my lord, notice Supreme Court suo motu proceeding came into force,
Yes.
my lord.
Till when?
It was up to, my lord, up to March, my lord,
March of
2022, my lord. What are traffic? Right for an again. Huh? So it is within, I have checked, my lord, subject to lordship direction, my lord. It is up
Okay, let us see the order of the High Court of 14/7.
14/7.
Page
14/7 order, lordship will find that, my lord, pays 78.
7/8.
Yes, lord.
Yes.
Mr. Dale, learned counsel for the petition on the respondent prefers CRP number so and so before this honorable court, which is pending. This court state the proceeding of money suit number pending in the court of civil judge Borbetta. However, stay order is not absolute till the disposal or revision petition. Rather, it was extended to the date on which the relevant petition was listed. The learned court below fixed the suit on day-to-day basis and on 31/2020, while the suit was fixed for passing the necessary order, it was dismissed. As the plaintiff petitioner failed to take step, being aggrieved by the said order dated so and so,
This CRP was by you. Why?
my lord,
This CRP was filed by you. Why?
filed by you, because my lord, it is out of bona fide mistake. They have filed, would have filed it under order 9 rule 9, against the order of dismissal of 31/2020. So this was wrongly filed before this honorable court. CRP was
This
according
was
to their it
withdrawn.
was
This was
withdrawn.
withdrawn.
Withdrawn, my lord,
And
with
it-
liberty.
But you say that it was dismissed for second time on 31/1/2020.
My lord. It was withdrawn, my lord. Lordship will kindly say it was withdrawn, and thereafter, my
No,
lord,
no, see, let us have the facts clear.
my lord.
You said that the suit was initially dismissed for non-prosecution on 6/11/13,
13 lordship.
and you had applied for under ordinance rule 9,
Lord.
along with the section 5.
Yes, my lord.
Both were allowed
Yes.
and both were unsuccessfully challenged in the High Court.
Then one was unsuccessfully, my lord, challenged because lordship, as I said, my lord, mixed case 26 of 15 and mixed case 27 of 15, if your lordship know. 26 or 15 was for restoration, my lord, under order 9 rule 9.
Oh, that was pending.
That was pending, my lord.
What was the number?
26, that, my lord, CRP lordship will find that order. Huh? Let's go to.
31. Just give us the number.
CRP number. Wait, I can see that. That order lordship will find
No, what is
that
the
pays
number-
80, my lord.
Number of the CRP?
CRP is, my lord, 26 of 19. It pays 80, my lord. Pays 80.
Let us see this order. How was it demanded?
Yes, my lord. May I read, lordship?
Let us read the operative part.
My lord, you'll find that court has discussed everything, my lord, now. Respondent filing application, lordship, may. I have, para 82, page 82, my lord. I have heard, second, I have heard the submission made by the learned counsel. The suit was dismissed due to non-prosecution. As such, the plaintiff respondent filed the application for restoration of the suit under order 9 rule 9 CPC. It is provided under the said provision that when the suit was dismissed under order 9 rule 8 of the CPC, the plaintiff is precluded from bringing a fresh suit in respect of the same cause of action, but he may apply for an order to set aside the dismissal aside. And if he satisfied the court that there are sufficient cause for his non-appearance when the suit was called for the hearing, the court shall make an order setting aside the dismissal upon such term as the court as to the cost or otherwise. On perusal of the impugned order, the net court below came to the finding that the ground mentioned in the petition was not substantiated, as there was only one Hokalotnama appointing DC Nath, and there was no evidence on the record that the plaintiff respondent engaged another advocate, Mr. Bishmoy Das. Other submission are also not proved. After the said observation, Lalaland Court below allowed the application under order rule line of CPC by holding that there was a good ground for adjudication of the case, both in respect of the facts and law. In my considered opinion, undoing is not proper, as while deciding an application under order and rule 9, a duty is cast upon the court to examine the sufficiency of the cause shown by the plaintiff, and then only the court must record his satisfaction of the cause.
DC Nath is your advocate.
My lord. Yes.
DC Nath is your advocate.
Yes, my lord.
Then why is the finding and the observation and the finding are not matching?
My lord, DC Nath is my advocate.
No. The observation and the findings are not matching. Just
Yes.
read again on perusal of the impugned order.
My lord.
On perusal, the same paragraph which you've just read.
Yes, worship.
Or it starts from on perusal of the impugned order, Lalaland Court below.
Yes,
Seven lines from the bottom.
yes, my lord.
Please read on. Not from the last paragraph, second last paragraph, which you have just read.
Yes, my lord.
On perusal of the impugned order, Lalaland Court below came to a finding that the ground mentioned in the petition was
Yes.
not substantiated. Page 82,
Yes,
which you have just read.
yes, my lord. On perusal of the yes, my lord.
Yes,
On
please read.
perusal of the yes, yes, yes. my
Please
lord.
read. Please read again.
On perusal of the impugned order, the Lalaland Court below,
Impugned order means the order which has restored.
well, my lord, impugned order,
Impugned
By-
order is the order by which it was
my,
restored.
my suit was restored.
They are aggrieved, they had come before the court.
Court before the
So
court.
what is
my
the
lord. They
observation?
File a CRP, that
Yes,
is the
let us see the
observation.
observation. On perusal,
On perusal of the impugned order, the learned court below came to the finding that the ground mentioned in the petition was not substantiated. As there only one Ukalotnama appointing Mr. DC Nath, and there was no evidence on the record that the plaintiff respondent engaged another advocate, Mr. Bishmoy Das. On the submission,
other submission.
on the other submission
No,
was
other
was
submission.
also not proved.
Right.
After the said observation, the learned court below allowed application under order 9 rule 9 CPC by holding that there is a ground for adjudication of the case both in respect of facts and law, my lord. So after that observation, my lord, CRP was allowed, the matter was remanded to the trial court to decide the application afresh. But here, my lord, the admitted fact is that the defendant appeared, he filed a written statement admitting his liability to the 68 lakhs, my lord,
Third,
and paid 10 lakhs, my lord.
repeat let it count for the appellant who has preferred this appeal under order 43 rule 1C of the CPC, read with section 104. Put up. The appeal has been directed against an order dated 5/4/2023 passed by the learned civil judge Varpeta in mid-J case number 36 of 2022. There were two cases.
Two cases, my lord.
What is the other?
My lord, that my lord will find from the page, my lord, operative page 97, last part, my lord.
What is the number?
Yes, 26 of 2015, Miss J case number 26 of 2015. Lordship, last.
Why only one number has been stated?
My lord, this petition considered, along with that was also considered, my lord. If your lordship look into accordingly, the petition is rejected and this miss case along with miss case number 26 of 2015 are both disposed of in the light of the above order.
However, in the state order, comma, another mistake being mistake number
26 of
26
15.
of 2015 has also been disposed of. Recourse, the learned counsel for the applicant has submitted that the applicant was the plaintiff in the money suit in which, the defendant in his written statement had admitted a part of the claim and in fact had also paid some amount and the rest what to be paid by installment.
Well, page 28, Lordship, it is
Fair.
detailed everything in the
However,
documents.
on 6/11/2013, the suit was dismissed for non-prosecution. Full stop. Accordingly, the appellant plaintiff had filed an application under Order 9, Rule 9 of the CPC along with an application under Section 5 of the Limitation Act for condonation of delay, which were respectively registered as Meet case number 26 of 15 and Meet case number 27 of 15. Both the aforesaid Meet cases were allowed. Full stop. However, revision petitions were filed in this court. Full stop. While the CRP, while the revision petition against the order passed in Meet case number 27 of 15 was dismissed, the one filed against the order passed in Meet case number 26 of 15 was admitted. However, this court in the aforesaid CRP, in the aforesaid revision petition being registered as CRP number 26 of 2019 had passed an interim order of case which on 3/1/2020, which was extended from time to time. On 16/7/2020, the CRP was disposed of and the matter was remanded for fresh consideration and the interim order was also vacated. However, in the meantime, the suit was again dismissed for default on 31/1/2020.
No, 31 mile. 31 2000
On
301202.
On 31/2020. It is submitted that since there was an interim order passed by the Honorable Court, the state order could not have been passed. It is further submitted that though initially a revision petition was filed in this court, the same was however withdrawn with the liberty to approach the learned trial court by filing an application under Order 9, Rule 9, which was accordingly filed. By the impugned order dated 5/4/2023, the learned trial court has dismissed both the application. We post the learned counsel for the appellant has submitted that the reasons prescribed while dismissing the petition may not be correct and would require an examination by the appellate court. He further submits that when the defendant had partly admitted a substantial portion of the amount claimed, dismissal of the suit would lead to miscarriage of justice. That I admit that I call for the record. Let step for service of notice upon the sole respondent, be taken by usual process as well as by registered proceeding.
Oblige.
Please talk to 6 weeks along with service report.
Oblige.
May I please, Lordship? Madam, pass over for time being, my lord.
Who is there? As the sir.
My lord. Election and airport, my lord.
Okay, that,
Oblige.
what is the matter?
Matter is, my lord. The bill is challenge against the judgment and order passed by the learned district judge Dibrugarh awarding rupees 8 lakhs as permanent alimony against the high courts. Best challenge this order. As well, the appellant is suffering from various ailments and he is supposed to,
Oh, we had heard this matter.
my lord, last on fifth. My lord,
Okay, let him come. We had asked him to take instructions.
my lord, my lord, my lord,
We'll try to dispose of this matter. 8 lakhs, I think it's very reasonable.
my lord, my lord.
Let him come.
He will come, my lord, that. Oblige.
Yes, sir.
Lordship. This appeal is filed against the final order passed by the learned additional district judge. Page number 129. The fact is that as an appellant and the respondent are husband and wife, and their marriage was took place in the year 2020.
The order is regarding what?
Yeah, passing of the
Maintenance.
maintenance in under section 24 of the Hindu Marriage Act.
Okay. How much is the amount?
Amount is given ordered by the honorable court
How much?
25,000 per month. The main fact is that lady has the respondent has concealed her actual income before the trial court. Kindly peruse the page number.
What do you do?
Lordship,
What is your profession?
I'm a chartered account.
You
And my average monthly income is 14,000 per month.
14,000.
Oh, yes,
He earned 14,000.
yes. I'm earning only 40,000 per month.
Let us see your returns, IT returns.
Yes, we have annexed the IT returns. Is page number, kindly peruse the page number.
You earn less than a grade 4 employee.
Oh, just I am started, my marriage was Solomon is 2020. I'm a new enrolled in that field,
Grade 4 gets more than you 16,000.
but just as I have started my career.
When did you obtain your degree? He is getting 14,000 is news to us.
Kindly peruse the page number 73.
What proof did you give before the learned court regarding your income?
Income page number 73.
How has it been
It
discussed?
is it is discussed that my income is more than the wife. Lady is working as an assistant professor in the DBR college under Dibrugarh University, and she is a part-time MBA faculty member. That matter was concealed before the trial court at the time of hearing of that petition.
Why didn't you take up the issue?
We have raised this point, but that kindly peruse the page number 120.
120.
120.
Yes.
Paragraph number 2, that the opposite party very recently came to learn that the petitioner had investment in National Savings Certificate, so and so, and term deposit. And we have the annexed that document. And the matter, the calling for that record from the superintendent of post office.
No, that is something different. You have said that he is working as a lecturer. Where?
Yes,
Where have you stated?
Page number 99. Kindly peruse the page number 99.
99.
99. Paragraph number 3, that the petitioner has not disclosed her actual assets and liabilities before this honorable court for the reasons based on to her. And it is serious contempt of court due to the following reason, that the so-and-so disclose about her education and professional qualification so-and-so, but she is much more qualified than she is the holder of the degree of Doctor of PhD in the study of the ethical practices in higher education, and since in the year 2016. The opposite party files here with the notification for award of degree of the doctorate so-and-so from the registered Dibrugarh University, which is marked document number D.
Where is her income? You said that she is a assistant professor. Where?
Kindly peruse the page number
In your written statement, where?
in my written statement. It is start from the page number 34, 35.
35. You know,
Okay.
it's in your written statement.
It is my written statement, written objection against the petition filed by the petitioner, respondent wife.
So we are, that's page 99, isn't it?
This is, she, lordship, she has filed asset and liabilities in the honorable court as per the apex court verdict, but she has concealed her real actual income in that petition also. She has not disclosed her actual assets.
In the asset liability statement, you had filed your objection.
Yes,
In that objection, where have you stated regarding her employment, her income, where?
yes. Page number 42, kindly peruse the page number 42.
42.
Yes. Top of the number E. The monthly income of,
Yes.
monthly income of so-and-so is about 70,000 per month, and she is working assistant professor, academic counselor, PG Department of Commerce at so-and-so Commerce College, Dibrugarh. And further, she is the lecturer of Dibrugarh University in MBA distance course. She is used to act as an observer in conducting the examination, and further, she used to take the private tuitions as well. And number F, the monthly income of the so-and-so, that is myself, is 14,380 per month, and he is practicing independently.
Let us see the order.
Cooperative priorities, page number 137.
One, 3, 7.
Cooperative. Taking a cue from the aforesaid case law and the materials on record, it appears to me that the petitioner is entitled to enjoy the same status as the opposite party, and there is disparity in their income. So it is the duty of this court to bring about the balance between the two by awarding maintenance penalty to the petitioner, who is earning a lesser amount than the opposite party. And having regard to the fact that the petitioner has her own needs which cannot be fulfilled on her own income, and her husband is able-bodied person, is liable to maintain her in to the extent to the his
Let us
status.
see the discussion regarding the income. Regarding the income.
Regarding income,
You have proved to, you have failed to substantiate your contention that she is earning 70,000. That is the finding.
that is why we have called for the record, but that was not called for by the honorable court as the page number 122. We have called for the record from the superintendent of postal department. And she has not
Postal department, why?
because she has used investment in the NSC and the term deposit.
No, that is a different matter. That is a confusion you have to conclude. But where is the direct your allegation is that, rather your statement is that she is also an assistant professor earning
Yes,
70,000.
yes,
What proof?
The
how is it-
47, kindly peruse the 47 page number.
No, we have seen your government. What was the proof?
But yeah, for page number 47 is the proof.
47.
Yes, kindly peruse the page number 47.
Yes.
Dibrugarh Honubak's Kanoi College and member about the PG course, member. Last point, Doctor
47.
47, 47,
Yes.
yes. About the PG course, headline is there.
Hmm.
Dibrugarh Honubak's Sajal Kanoi College,
Hmm.
Commerce College.
Did you prove this document?
Yes,
This document was proved.
yes, we have submitted, but it is
No,
not
not
discussed.
submitted. Did you prove or not?
We have submitted that she is working as an assistant professor.
Submission is a different matter. In the evidence stage, did you? prove-
Evidence is not taken. On the point of the document, honorable court has passed. We have not, no, evidence is not taken. How can we prove that document? Moreover, petition number 1672 is not regarding the 1672 filed on the 22/9/2020 is not discussed. Without waiting for that document, honorable court hurriedly passed the order. When you file a petition for the calling for her income source, she immediately file a complaint before the disciplinary committee of the Institute of Chartered Account of India. It is page number 125. And that disciplinary in complaint petition, she has stated that she has admitted that she has NSC and fixed deposit. Illegal hacking of my personal account and documents vice investment in national saving account and term deposit scheme. And that fact was also
Was there any cross-examination?
Lordship.
Cross-examination was there or not?
No. They have not submitted any document, any examination is there. No examination is safe.
Heard. TK Board of Directors. When it counts it for the appellant who has referred this appeal into This was filed at 24.
Yes,
24.
Yeah.
What was is the divorce proceeding pending?
pending.
Will an appeal lie?
Yes. It's final order.
It's not a decree. See, now you have the Hindu Marriage Act
Yes,
28.
28.
Please read.
All decrees made by the court in any proceeding under this act shall subject to the provision of the subsection 3 applicable as decrees of the court and made in the exercise of the original civil jurisdiction, and every such appeal shall lie to the court to which appeal ordinarily lie from the decision of the court given in exercise of its original civil jurisdiction.
Number 2.
Number 2, orders made by the court in any proceedings under this act under section 25 or 26 shall, subject to the provision of subsection 3, be applicable if they are not interim orders. And every such appeal shall lie to the court to the which appellate appeals ordinarily
Only
lie.
on 25 and 26. 25 is for permanent alimony
Yes,
and 26 is for custody. But whether under 24 an appeal will lie,
yes. In PT Lakshman Kumar versus Bhavani, decided on 23rd April 2013.
Hmm.
Case PT Lakshman and Kumar and Mrs. Bhavani decided on it is honorable court hold that appeal lies. There's a finality is 24 petition is disposed of, it is final order.
only a pendency lie.
Yes, this is a final disposal. No interim is there. It is final disposal.
Understood, but it's only pendency lie.
Yes. Finality is there.
See, you can invoke 24 only when a proceeding is pending.
Yes,
You say that in here, divorce proceeding is pending, and therefore 24 has been filed. Now the orders under 24, maybe final orders, will an appeal lie against that?
Lordship.
Will an appeal lie against that?
Yes,
Or should you come for revision?
this is final order. Finality is
All orders in that way are final. But some orders, unless the statute provides for an appeal,
case is finally disposed of. Lordship.
the wording of 28, have you seen? Have you seen, do you have that order? That citation which you have just relied upon?
Sorry, right now I have no. The case number is PT Lakshman Kumar versus Bhavani, Mrs. Bhavani.
Citation,
Citation I have not.
we have it at 2 o'clock.
Yes,
Bring the
outline.
citation. We have certain doubts. To may convert this into a revision, that's not an issue. Well, to notice also, but whether appeal is maintainable. Come at 2 o'clock.
Oblige.
May it please the Lord.
instructions taken?
No, my lord, a very stubborn person, my lord. I could not persuade him, so it's all up to your lordship. And only thing,
We'll fix installments.
beg your pardon.
We'll fix installments.
Your lordship pass an order today itself.
Today, you know, if we have it in installments, we'll not
Yes,
put
yes.
too much pressure upon you also.
My lord, from my side,
Obviously, we're not recording.
can I pray that 6 months' time, if your lordship can? Otherwise, he was talking in a way that is not possible at all.
Part three as Dr. and senior counsel for the appellant, who by means of this appeal has put to challenge a part of the judgment dated 12/4/2023 passed by the learned district judge, Dibrugarh, entitled to within bracket divorce, bracket close, number 35 of 2017. Full stop. The proceeding was initiated by the appellant as petitioner under section 13 within bracket 1 within bracket small 1A of the Hindu Marriage Act for dissolution of the marriage. Full stop. By the while the judgment dated 12/4/2023, while the prayer of the while the petition of the appellant has been allowed and divorce has been granted, comma, a permanent alimony of rupees 8 lakh has been directed to be paid within a period of 3 months. Full stop. The grievance of the appellant is with regard to the quantum of the permanent elements. The senior counsel has submitted that before arriving at the state quantum, comma, there was no adequate discussion and the relevant factors, including the income and expenditure incurred by the petitioner, incurred by the appellant, was not taken into consideration. It is the specific case of the appellant that is suffering from various ailments in which there is huge, for which huge expenses are have to be incurred. Full stop. Where the this court, while taking up this matter on 5/8/2020, had recorded a prima facie opinion that the amount involved may not be in the higher side, and higher side, in which the business of the petition was also taken note of. Para. Accordingly, comma, some time was granted to the learned counsel for the appellant to have instructions put to para. The senior counsel, however, submit that the present challenge would be, and that the appellant would persist with the present challenge. Full stop. Para. The impugned order, judgment and order dated 12/4/2023, while assessing the permanent alimony, are taken into consideration the annual income of the petitioner and such income for the financial years 2018-19 2022-23 were taken into consideration. The claim of the wife was that the petitioner was earning about rupees 10 lakh per month as he was the lessee of a Sen Mohar, owns property and also owns 2 numbers of wine shop. However, the Planet Court has taken, and Planet Court, in the opinion of this court, has taken a very reasonable standard, and the amount of permanent alimony of rupees 8 lakh may not be held to be on the higher side at all. In that view of the matter, this court is of the opinion that the present may not be a fit case to be admitted, and according to the appeal stands dismissed. This court, however, would slightly modify the terms of payment that the state amount of rupees 8 lakh granted by the learned district judge Dibrugarh as permanent element is to be paid within a period of 6 months from today. However, an amount of 4 lakh is required to be paid within a month, and the rest and the remaining 4 lakh within the period stipulated.
Ablash.
Appeal stands disposed. Motion to change. Admission है. Nothing. Orders. Orders. Orders to the headquarters. Orders why?
Lordship, today matter is fixed for consideration of stay order, Lordship. This is a matrimonial transfer petition, Lordship, for transferring a matrimonial dispute from the court of the learned district judge Dibrugarh to the court of the learned district judge Jorhat, Lordship.
If I will file in this case, I will file objection, my lord. So, sometime may be given.
Lordship, I pray for some interim protection, Lordship, because no stay was granted in first date, Lordship, and that was the indication that it will be considered on returnable date, Lordship. Wife is the present petitioner, Lordship. She is suffering from hepatitis B, Lordship, so it is unable to her to go to.
You are speaking from Dibrugarh to
Jorhat, Lordship.
What are your grounds?
Lordship, she is suffering from hepatitis B, Lordship. I have annexed a medical document, Lordship.
What has been, what is the proceeding?
That is,
Certain petition
no, 11 petition. Boy, to declare the marriage as void marriage, Lordship.
by the husband.
Husband, Lordship.
Okay.
And Lordship, she has no source of income, Lordship, and 138 kilometers she is unable to travel, Lordship, from Jorhat to Dibrugarh, Lordship. And no one there to accompany her, Lordship. Her father is also totally bedridden, and I have made categorical statement, Lordship. So at this stage, Lordship, still his filing of the objection that proceeding may be stayed, Lordship.
You filed your objection to heard MS P. Bhattacharya, the counsel for the petitioner. Also heard P.
Hey, how are you?
A.
How are you?
Hawari, learned counsel who has entered appearance for the sole respondent. Sarah, the learned counsel for the petitioner, by referring to the order dated 27/6/2023, has submitted that while notice was issued, there was an observation that the interim chair of the petitioner would be considered on the next returnable date. Para, by referring to the averments made in the petition, comma, made in the petition for transfer, comma, the learned counsel for the petitioner has submitted that the respondent has filed title suit N number 11 of 2022 under section 11 of the Hindu Marriage Act 1955 for dissolution of the marriage. So, it is submitted that the petitioner, who is the wife, is a resident, is residing at Jorhat, and it would be difficult for her to attend the proceeding at Dibrugarh, which is at a distance of about
138 kilometers.
138 kilometers. Also, the medical condition of the petitioner has also been highlighted. Also, para, the Hawari learned counsel, however, prays for some time to file objection. Also, para, balancing the equities and in the interest of justice, it is directed that till the next date fixed, comma, further proceedings, the insurance shall remain suspended. Full stop. The aforesaid order, however, would be reconsidered after filing of the objection by the respondent. Full stop, please. On, yes,
10 days time, my lord.
10 days. No,
10 days.
please, on today. Let's take the 9, not the 9, huh? The 8. We'll have it on 1st of September. Okay,
Yes,
1st of September, Friday.
Obliged, Worship.
Yes.
Lordship, my friend has appealed, Lordship. If he wants to take time, he officially has not been served with any copy.
Lordship, I have received the copy from the, through the responder, the petitioner, Union of India, Lordship.
You are seeking review of what?
Lordship, seeking the review of the appointment of the arbitrator, Lordship. Substitute arbitrator, Lordship. The ground being, Lordship,
Or you said that she is appearing against you.
in few of the
Yes,
cases.
sir. The allegation is she is appearing in writ petition against me, in favor of me, Lordship. But Lordship, this is the order also given by the arbitrator that she never been appear for me. This is
Not
the
for
order.
me.
This is our
Against the MES.
Lordship.
No, the allegation is not that she is your counsel or has acted up as your counsel. She has appeared in a number of matters against the MES.
MES.
Sir, it doesn't make any difference, Lordship. Claimant is myself a claimant, claimant mine. They have no claim, Lordship. That's it. That is why the Honorable Court has appointed the arbitrator. I have gone for appointing an arbitrator.
No, the initial appointment was somebody else who had passed away. And in the meantime, the developments were that this particular person who has been now acting as the arbitrator, she had appeared in some matters against the MES.
So sir, MES have no claim, Lordship. That doesn't matter. Claim is mine.
Against whom?
That is, Lordship, if one more thing is, Lordship,
No, no,
this is
the claim is yours against whom?
against the Union of India, Lordship.
Union of India is a very broad concept. Against which component of the Union of India?
Lordship, the thing is, if she would have appeared before me, then
You're not
she can
answering-
benefit to me.
You're answering the question. Answer the question.
Lordship,
Against whom is your claim?
my claim is Union of India, Lordship.
Which component of Union of India?
That is CWE Borja, Guwahati, Lordship.
Against? What is the?
In, that
what
is
is the
representing,
rotation?
Lordship, this is. The Union of India representing, that's a number 3, petition number 3, Commander Works Engineer.
TWE Air Force Water, what is this, Mr. Chakraborty?
Lordship, it's a MES from MES, Lordship,
It's part of MES.
MES.
But he may also be correct that he has not appeared as his counsel.
That's true, Lordship, but he's fighting against the MES and my friend may be there because he's one case, he's
No, she is not the litigant.
counsel of the MES Builder Association, Lordship.
No, she is
Obviously,
not-
he should be a member of that association, Lordship.
She is not the litigant, she is the counsel.
Lordship, that's true, Lordship. And moreover, we never consented to her appointment. Neither we objected, that is written, Lordship. In fact, the CW Borja never received any notice,
She
Lordship.
has acted professionally for some matter. If she was also the counsel of the other side, then
Lordship.
matter would have been slightly different. Now she has been appearing as a counsel in some matters of MES,
Lordship, that's
with
true.
which he has no connection.
Lordship, that's true.
That
But
is perhaps what is trying.
he has to make a,
Lordship.
Lordship, he has to make a declaration under 12, that's, that.
Has it been done or not?
No, that has not been done. That
has
has
to be
also
done.
been not been done.
That has to be done, that's mandatory nowadays, under the Arbitration Act, that you are not connected. At the beginning, that's the foremost thing you
Lordship.
need to do.
Lordship.
One legal matter I want to put. Lordship, there is 7-bench judgment of the Supreme Court. They say, the Supreme Court says once the arbitrator has commenced already and they file the defense, as they have not put the objection before the arbitrator, they cannot put it. Then they have to wait for the final award. But arbitrator himself says, I have not connected with me.
Where? Where has it been said?
This is now.
Has the declaration?
Yes,
come?
I'm coming. Lordship, this is the reply on when they have given taken a suspension order. The arbitrator immediately replied it to them also or me also. I'm submitting this matter. They have never been connected to me.
No, her, where is the declaration?
आपको भेज दिया है उन्होंने। ये भी ले लीजिए।
Lordship, this he wants to project is a declaration, Lordship.
No, you file an affidavit. Let him file the affidavit. I think we should give him an opportunity of hearing.
Lordship.
Lordship, this is 15 years is going on of this case, Lordship. And the review, they can file the objection before the arbitrator as per law, Lordship.
You file
Then they come up, come over here, Lordship.
you file your
That,
objection. Okay.
That's
Yes, you have
kindly fix for 14, Lordship. One.
What was it? Uh,
16 benefit.
मैं
14 मतलब
Third, repeat Chakraborty, let us see this.
मैं तो बाहर से
This
आता हूँ।
matter
बाहर जाता है पेट्रोल
was
पीने
taken
अलग
up on 2/8/2023
तो अभी भी नहीं रहता हूँ। लेकिन
And on
आज
being
छह
informed
साल से बाहर से आ रहा हूँ।
that the proceeding was related on the next date, that is 3/8/2023, this court had directed an order of temporary suspension of the arbitration proceeding. For today, the Shastri D.T. Himan
Lord.
has appeared and has objected to the present petition for review. For such objection may be put in the way of an affidavit,
Lord.
which may be filed within a period of?
14th lordship. Actually, I want hearing on 14th lordship. Before
When
that,
can you file the affidavit?
on 14th. The hearing can be done on 14th lordship.
No, no, when can you file the affidavit? Today or today?
No, today is, I'll file the affidavit after 2 days, lordship.
Uh,
2-3 days actually. Before on Friday, I'll file Friday on Friday.
period of a week from today. As agreed to by the parties, based on 14/8/2023. Interim order passed today to continue to the next set of days. You bring the judgment also, you are referring to some judgment.
Lots, I'll bring lots.
Oblige.
Oblige, Lord.
And on the declaration part,
Lordship.
you, there are judgments.
Lordship. Make these a launch. Look, yo.
Just a minute.
Yes.
We're taking this for final disposal, Mr. Muzumdar.
My lord.
Taking this for final disposal. No, look, yes,
Lordship will kindly come to the decision of the division bench here in this case. Because the issue was relating to the allowing the central tap holders, candidates to
central
participate,
cat holders.
central tap qualified candidates to participate in the recruitment process that was initiated. We did the advertisement dated 11th September 2020.
You just narrate the fact first, that will be convenient for us. There was an advertisement
There was an advertisement at Annexure 1, page 57,
dated
dated 11th of September 2020.
11/9/2020.
Yes.
Advertisement for
Advertisement for filling up of post of LP school teachers. Here it shows, my lord, for filling up of 3,941 vacancy of assistant teachers in LP school and assistant teacher, science teacher, Assamese language teacher, and Manipuri language teacher of UP schools, upper primary schools, under the director of elementary
LP
education.
and UP.
Yes, UP, both. And there,
The number of vacancies 3941.
3941.
Okay.
And there, they put a condition that Assam teachers eligibility test qualified candidates shall be allowed to participate.
The TET from Assam.
Yes, that from Assam. So thereby they excluded the central TET qualified candidates who were allowed to participate till then in all the recruitment process by the state. Till the last recruitment process that was initiated, they were only allowed, central TET qualified candidates were allowed to participate. But this time suddenly they put the restrictions that they will not be allowed. Therefore, the candidates, some of the candidates approached this honorable court by filing WPC 3720 of 2020. 3720 of
They
2020.
were also centrally qualified,
They are all central,
qualified in central TET. They are also qualified as in central TET.
central TET. They are all central TET
Okay.
qualified
Now
candidates.
the candidates in WPC 2720 petitioners, they are similarly placed like you.
In other petition.
They are similarly placed like you.
Yes, 3720, they were central.
Yes.
All are similarly placed. They are batch of petitions.
Other petitions also filed like this.
Yes.
This was the lead matter,
This lead matter was, this what was the lead matter?
3720.
3720.
Okay.
Vinod Karmakar and others. And when, Lordship, at this point, I will just place when this petition was first moved. Lordship will find they were allowed, the learned single bench allowed the petitioners to submit their application because that's an online application. But their applications were not accepted by the format because of central when they so.
Correct.
So they were allowed to submit their applications offline.
Okay. Now what was the order dated?
24th September 2020.
High Court allowed.
Yes. High Court allowed them. Lordship will kindly have a look
Online participation,
on offline application.
offline participation.
Offline, they were allowed to submit their applications offline.
This is, where is the page?
Page 88, Lordship will kindly come to.
88.
88, 88.
Yes. Yes, please.
Guatemala. Lordship will come to the third para. Considering the matter in its entirety, it will be necessary to grant some interim order to the petitioners. It is directed that the petitioners be permitted to file their applications offline and submit it in the office of the Director of Elementary Education, Government of Assam, Respondent 3. In view of the fact that this court is seized of the matter, as the last date for online submission is up to 12 midnight on 26/9/2020. The writ petitioners are permitted to submit their offline application forms up to 4 p.m. of 28/9/2020 before the authorities. In other words, the petitioners are permitted to submit their applications in physical form before the office of the Director of Elementary Education. The matter will be listed on returnable date. The effect of the interim order passed shall continue till Monday, 28/9/2020 till 4 p.m. Then, Lordship, next para is important. It is assured by Mr. Soikia Landis Senior Counsel that in the event the writ petition is allowed, the candidature of the petitioners will be considered as per law on the basis of the offline application forms submitted before the authorities by virtue of this order. That was the assurance given, that was recorded. Now, ultimately, unfortunately, my writ petition was dismissed by the learned single bench.
When was it?
That was dismissed. No. 18/12/2020. That is not annexed here, but then this is recorded in the
It doesn't matter.
division bench order.
You had preferred an appeal.
We have gone on appeal. We did go on appeal, and the appellate court ultimately,
What is the number?
appeal number is 24, read appeal number 24 of 2020.
21.
Huh? 24 and
It is 21. Or 22.
of 2021, yes. Read appeal number 24 of 2021. What you will find it relevant page of 94.
Yes.
Well, the entire judgment has been placed. Ultimately, all aspects were discussed law was discussed. And finally, the petition was, writ appeal was allowed. I will take your lordship to the 126 page lordship will kindly come to.
One 26.
126.
Yes. Paragraph 53.
53, lordship. And
Yes.
Lord, before that, lordship may also read 52.
Hmm.
It has been stated at the bar by the learned senior counsel appearing for the state that since there was no interim order operating in the writ petitions, the process of selection of candidates pursuant to the advertisement dated so and so, involving only the state that qualified candidates, has progressed. And at present, the same is at an advanced stage. Process was at advanced stage. Mr. Soikel and his senior counsel for the state has also submitted that if the entire selection process is interfered with at this stage, the same would adversely impact a large number of schools facing acute shortage of teachers than 53. There can be no doubt about the fact that the ultimate beneficiary of this recruitment process would be the large number of children who may suffer if there is undue delay in appointment of teachers. We are also conscious of the fact that there are 3941 vacancies advertised by the department, and the total number of writ petitioners who had approached this court is 916. Pausing for a moment here. This 916 includes two groups.
LPUP.
One is the LPUP and the other is the SSA. Simultaneously, there was another petition for Sarva Shiksha Abhijan. They advertised certain posts, and there also they put this bar that the only state that can, not the central can.
That means those vacancies are beyond this 3941.
Yes,
The recruitment process.
yes, 394, 3941.
3941 was the initial number of vacancies.
Initial number of vacancies in the DEE.
Yes, now you say that this 916 include for persons like you
We have given a division here.
as well as SSA.
SSA candidates. SSA candidates. So there were some numbers of SSA candidates. That group, that petition was also allowed.
CTET as well as SSA.
Yes. Breakup we have given. Well, D lordship at this stage note DEE 581 and SSA 335. This is how it comes to 916. That was the calculation.
DE means
Director of Elementary Education.
Oh.
That those posts advertisement. Director of Elementary Education 581 candidates appeared under Director of Elementary Education with Central TAN. They filed cases.
okay.
And in Sarva Shiksha Abhijan, 335 candidates were there who came before this order. 335.
All these candidates are seated.
Seated. Therefore, both these petitions were decided, appeals were also accordingly allowed. And therefore, here this number of posts, total calculation was given by the state side, and therefore the court noted this. In our petition,
Yes.
para 9, page 49, lordship will find the breakup. We have-
Doesn't matter, we have noted.
Yes,
You say that out of this 916 number of total candidates.
Yes.
581 had aspired to be for appointment under the DEE and 335 under the
yes, yes. We make it very clear that all these 916 candidates shall be considered against the existing 3941 vacancies. But then, my lord, actually 3941 vacancies, out of that, not all, 581 only come in. Others are SSA. But even if their candidature is ultimately accepted, all the writ petitioners, including the present appellants, can at best fill up 916 vacancies and no further. Although there are only 50 appellants before us who have assailed the impugned judgment and order dated 18/12/2020, passed by the learned single judge. Yet, since the impugned judgment has been set aside, and in order to avoid future litigations on the same issue, we deem it appropriate.
Understood, doesn't matter, yes. It
So-
will be covered for covering all these.
All. It was made open for everyone, even those who have not come.
The dismissal was by Honorable Justice.
Honorable Justice Bujabura. Avoid future litigations on the issue, we deem it appropriate to grant similar relief. Well, that WPC was 4174/2020. Common judgment.
It included 3720 also.
Yes. Yes. 3720.
It is,
Out of them, only 50,
it is 41
even number two,
WPC
417, 74 of 2020.
4174.
Yes, 2020.
Okay.
Now, page para 54. Considering the facts and circumstances of the case in its entirety and balancing the equities, we direct that the recruitment process initiated by the department on the basis of advertisement dated 11/9/2020 be now processed in 2 phases. In the first phase, appointment orders for filling up of 3025 out of 3941 vacancies may be issued from among state that qualified candidates. The appointment orders in respect of the remaining 916 vacancies be issued to the eligible candidates in the second phase after considering the candidatures of the 916 writ petitioners, which includes the present appellants who are central tap qualified candidates. It is, however, made clear that the appointment of the writ petitioners appellants would be subject to the condition that appellants have the state tap qualification and other guidelines prescribed by NCT, and they fulfill all eligibility norms prescribed by the advertisement notice dated 11/9/2020, including necessary proficiency in the required language. My lord, Lordship has noticed that little inconsistency here in the last part. That was a mistake
It
committed.
should be seated, I think.
It is seated allowed, but at the same time, the last line goes contrary to this.
I think state should have been
Yes.
seated qualification.
That should have been, my lord,
Central tap.
ultimately clarified. Then next clarification, this has been issued on our application. Lordship has noted the date, my lord. This order was delivered on 24/9/2020. Sorry, 3/2/2021.
3,
3/2/2021, this writ appellate judgment.
okay.
Right? Like to go. What the kind of? And thereafter, immediately thereafter, we filed the IA. Next page, to 128,
You
Lordship, we
get the
find
date at page 89. Page 89.
page 89.
So the different format of the judgment.
Yes, it is in the top. I'm sorry, it didn't strike my eyes. We used to see in the video afternoon. What is name? It's a format has seen. 29 January 3rd February 2021, judgment was delivered.
Yes.
Yes. I'm grateful, Malam. Then immediately thereafter, we filed the
Verification.
IA.
Verification.
Yes. Next page, that IA Civil 258 of 2021 was filed.
Relevant part 155.
155 relevant part, page 155, Lordship may kindly come to. This was finally disposed of on 12/2/2021.
Yes,
Lordship may kindly come to 155.
yes, yes.
Now, it says, my lord, this is a short order, I will read,
Yes, we have seen
Lordship,
last part.
last part, right then. In the said sentence, the words, the state TET qualification and other guidelines have come up due to inadvertence. Instead of the words, the state TET qualification and other guidelines, it should be other qualifications in the guidelines. Let the words other qualifications
Yes.
in the guidelines be substituted for the word the state TET qualification and other guidelines in our order dated 3/2/2021.
Yes, yes.
This is the qualification, the clarification issued. Now, my lord. Here, two dates are crucial, Lordship may also kindly note, because they have taken a plea. I will come back to that. Before that, I would like to place the facts. This IA for clarification was filed on 4/2/2021. Final order was on 3/2/2021, my lord. Immediately on the next date,
You find this.
we filed this. Lordship will see this from this we have downloaded. Yes, sir.
Doesn't matter. Okay,
Yes.
then
And then,
it was disposed of on 12/2.
yeah, but before that, on a 5/2/21, the matter was listed. 5/2/2021, the matter was listed. And finally, they took time to submit opposition, affidavit in opposition. They wanted to oppose this. Court granted them time. Meanwhile, they are saying that nothing is going to happen within these 2 days. Asal order. They filed this objection on 11th and 12th, the disposal came. They knew that this I has been filed for clarification. So on 25/1/2021, when we moved this application, then the London division bench, honorable division bench also recorded on the basis of the statement made by the
25/1, not on 25/1.
25/1/2021.
What is it?
It says that no interim order is required since a statement has been made.
25, it cannot be 25/1.
It's a writ appeal order, first order of the writ appeal, 24 of 2020.
Okay. In WA 24/21, not in the IA.
24, not sorry, yes, not in the IA.
There was an interim order.
Yes, there was an interim order.
Okay, what is the
24,
date?
2021,
24,
2021.
2020, 24.
24 of 2021, order dated 25/1/2021.
25/1/2021. What's the order?
It says no interim order is required since a statement has been made by Mr. Soikia that no appointment order shall be issued till day after tomorrow, But this ultimately, they didn't make any appointment that time, it continued. Right?
We'll come within 5-10 minutes. We'll take a short break. We'll come.
Sorry. SLP by the government.
Which order?
This division bench order.
3 to 21.
Yes. After this, I was allowed corrected order. Corrected order was put to challenge before the apex court. And Lordship will find the order at page 157, next page, Annexure 5. SLP was dismissed. So after hearing at length on the same very day, my lord, this order was passed. SLP was dismissed. And therefore there leaves no scope for the state to not implement the order of the division bench.
This is 3-9. 3-9.
3920.
Shall be dismissed.
SLP dismissed. 3921.
Okay.
That's the facts, and then court said no. Now, thereafter what they did, my lord, they were waiting for long without doing anything. So 3/9/2021 and then 22 came, they were not doing anything. We had to file a contempt. Contempt is still pending.
296 of 2020.
Contempt petition number 296 of 2021 was filed.
19/8/2021.
It was filed on
19/8/20.
19th August 2021. Contempt was filed.
19th August,
19th August 2021.
before the SLP dismissed it.
No, no, yes, yes. Before that, because the SLP was filed very belated. It was pending, then they moved it.
Yes.
And that was ultimately notice was issued. Contempt notice was issued. And then, well, kindly come to 159 page. Annexure 6. They issued this notification, advertisement, dated 4th May 2022.
Yes.
4th May 2022, page 159. They issued this advertisement purportedly in compliance with, Lordship will kindly read this along with me. In compliance of the Honorable Guwahati High Court order dated 3/2/2021, passed in writ appeal number so and so 24 of 2021, and order dated 12/2/21, passed in IA 258/2021, and contempt case number 296/2021 out of writ appeal 24 of 2021. They meanwhile received notice of contempt along with IA 254/2021. And Government in Elementary Education Department, Assam, instruction VDA number so and so dated 8/10/2021. Online applications are hereby invited through the official website of DEE, Director of Elementary Education, Assam. That is so and so. Only from the writ petitioners involved in the concerned WPCs and fulfilling all other eligibility criteria for filling up of remaining vacant posts against advertisement dated 11/9/2020 for the post of assistant teacher of LP schools and assistant teachers of UP schools under the Director of Elementary Education, Assam.
Mm.
The read petitioners are requested to visit the official website of DEE Assam, that is so and so, and fill up the online application form and upload the following documents from the midnight of 25th May 2022 to the midnight of 25th June 2022. Any other required details regarding this advertisement will be uploaded in the official website of DEE Assam, that is so and so, before opening of the online application system. The read petitioners must mention the WPC number and the serial number of her name in the read petition in the relevant fields while submitting online application, and the selection will be done in compliance of the final order and directions of the Honorable Guwahati High Court in the read appeal number 24. Those who have already submitted offline documents in the office of the undersigned also need to apply. It says. And then these are the scanned documents. All this criteria has been laid down. So accordingly, we submitted. My understanding is that since initially it was all offline, now they wanted to take it through the line, online basis for their convenience. It would be easier for them to consider. That is why they wanted that we should upload. They made the link open to us and we did it. We did it. And thereafter, on 25th May 2022, this another notice has been issued at page 161. It is for information of all concerned that this online application system is designed to capture the necessary information in respect of petitioners of the Honorable Goa High Court. Case so and so, all these are mentioned. Order date so and so. To assess their position in the already prepared final select list. Kindly see, my lord. To assess their position in the already prepared final select list against already completed recruitment process, VD advertised dated 11/9/2020. They say that process was completed. Our position in the select list, they will verify. That is why they designed this online portal. All the terms and conditions for advertisement number so and so dated 4/5/22 will remain the same.
Yes.
No issue, gone. Now, ultimately they have come up with this notification at page 162 dated 28 October 2022.
Yes.
It says in continuation of the Assam advertisement number so and so dated 4/5/2022.
Yes.
District-wise, medium-wise, and category-wise breakup of remaining vacancies after appointment of regular teachers on 5/2/2021 against advertisement dated 11/9/2020 are given below. They have referred to the advertisement dated 4/5/2022. 4/5/2022.
159. We have
159. That is the advertisement where they said that you just upload.
Yes.
It didn't advertise any post. It simply referred to the original advertisement. Now they say that in a continuation of that advertisement 4/5/2022, the district-wise, medium-wise, category-wise breakup of remaining vacancies after appointment of regular teachers on 5/2/2021 against advertisement dated 11/9/2020 are given below. Here, Lordship will find districts, left-hand column. These are the districts. Then EWS category, OBC, MOBC category. This is Assamese medium schools, my lord. Assistant teachers, LP schools, SC, STH, STP, unreserved, remaining vacancy total, category wise. Here, Lordship will find EWS 0, OBC, MOBC 0, SC 0, STH there are posts in district wise, STP only one post, unreserved 0. We do not belong to STH and STP. We belong to OBC, unreserved, MOBC, SC and EWS, where posts are not shown at all. No post. UPS, well, kindly see. I mean, Bengali medium or something. Next, Bengali medium, next shown 163 page. Table 2, my lord. Bengali medium schools. EWS, no post. OBC, MOBC, no post. ST, no post. STH are there. We do not belong to ST. STP, there. Unreserved, no post. So also Assamese medium schools in UPS, upper primary schools, table 3. EWS 0 entirely, OBC, MOBC 0, SC 0, STH, STP, few posts are there, unreserved 0. Total. Bengali medium, table 4, Bengali medium school, assistant teachers, upper primary schools, EWS 3 districts, there are few posts. OBC, MOBC, 2 districts, there are few posts. ST 0, STH is there, ST unreserved, only 2 districts, 5 posts are there. আমি Bengali medium. Hindi teachers, table 5, we are not on that. Hindi teachers are 9. Assamese medium school Hindi teachers, EWS category, (36) posts in some districts, including all. OBC, MOBC, they have shown. SC also there, STH also there, STP also there. Few posts are shown there in all the categories. Unreserved is also there. Medium, table 6, Bengali medium school, Hindi teachers, upper primary schools. There are posts, they have shown, it is there. Now, our case is that in view of the order already passed and in view of the assurance already given that they will all be considered against their respective categories, and in view of the fact that they didn't tell that there is no post we cannot implement before the apex court, they are only challenging legality of the division bench order, directing them to fill up remaining vacancies out of this which are the holders, those who have already applied. How can they now say that there is no post and we cannot comply with the order? That is a situation created by them. They have filed an affidavit. Lordship will kindly take up their affidavit. It was filed on 24th of July, 2023. Well, Lordship got the affidavit. Yes. Kindly come to paragraph 9. That with regard to the contents of paragraph 14, 15, 13A, 14A, 15A of the petition, the answering deponent states that the writ appeal number 24 of 2021 was disposed of on 3/2/2021, directing the recruitment process initiated. Well, that second page, para 9 of the affidavit filed by the director
Yes.
Elementary education. That with regard to the contents of paragraph 14, 15, 13A, 14A, and 15A of the writ petition, the answering deponent states that writ appeal number 24 of 2021 was disposed of on 3/2/2021, directing the recruitment process initiated to be processed in 2 phases. In the first phase, appointment orders for filling up of 3025 out of 3941 vacancies were required to be done from among state TET qualified candidates. The remaining 916 vacancies were then to be filled up by eligible candidates who were seated qualified with a condition that the applicants had state TET and other guidelines prescribed by NCTE and they fulfill all eligibility norms prescribed by the advertisement concerned. They are referring to that particular paragraph which created the match. Accordingly, the recruitment process was completed on 5/2/2021. Can you see, madam? 3/2/2021, the final judgment, writ appeal final judgment was delivered. 4/2, we filed the application for modification. They received the copy. And they say that 5/2, they fill up. Interlocutory application number 258/2021 disposed of on 12/2/2021. And therefore, the vacancies remaining after the selection and appointment of state TET qualified candidates have been shown for considering the beneficiaries of the orders passed in writ appeal number 24 of 2021. Who are the beneficiaries of the writ appeal court's order? Now they are posing a question here that only those posts which have remained unfilled, only against that only they can be considered, not beyond.
And the remaining posts are for categories in which you do not belong.
I do not
So you are being denied.
deny. Yeah. Alert, what is the intention? I ask for submission. They know. They know the consequences. They know that there was a wrong line came in. Maybe a typographical mistake in the main judgment, where it says the state TET qualifications.
But Mr. Mohanto,
But-
you have also referred to 161, page 161, which is the notice of 25/5/2022. Now, if that notification is being issued to verify and assess your position in the select list, then where is the question of going for the residual vacancies?
Yes,
You have to be given scope as per your position in the select list.
select list.
There is no question of the remaining vacancies now.
Exactly, Malad, this is one point. And the other point is,
If
they
somebody
have
is
not-
appointed who is below you, you give him notice and
yes,
accommodate him.
exactly. That is one part. And second part is, my lord,
But at the same time, if his position is below, then the matter ends there. It's only of consideration as per the select list.
but they
And if
say,
the vacancies presently do not match with their categories and they are in the select list in such a position that it is only in these vacancies where they can be considered, then matter ends there. But if their position is above the last person
yes,
in their category, then they should be accommodated
exactly.
because their seated has been clarified by the court.
Yes,
That will not be an hurdle now.
I am grateful, my lord. Other part, lordship will kindly consider. If they say that since their applications were filed offline, we didn't consider that time itself.
No, then that notice will have no meaning. Where is, how do you assess now?
Exactly. How they will assess it? Will have to be assessed along with all the,
Oh, just to clarify one thing, the recruitment process after you file the submit the application, there were some. What was the process? What did
they
you do?
will go for verification.
No. What is the process thereafter? There is some test. No,
No, nothing, nothing,
It is only
simply
on the
on the
basis
basis
of
of the
the
marks,
marks obtained.
only marks obtained.
So that is.
So therefore, what they do, they initially verify, they call for verification of the
So it is
records
an
and-
objective assessment of the marks which you have already done, obtained in your previous examination.
Yes.
There is no entrance examination.
Nothing.
as such.
Nothing. No interview, nothing.
Understood.
Only that. Therefore, well, if they consider our case against those respective categories.
The
of
only
vacancies,
difficulty initially was that you were CTET and the advertisement said state TET.
state that.
Now that has been clarified, the CTET and state TET, pre-TET part.
Yes.
Now you say that if you are above the last appointed candidate, it
Yes.
should be
You
given.
should be given.
And the stand which now they are taking, that it was over 9 to 5 to 2021, that perhaps is not a
Not,
reasonable stand. And secondly, since showing the table that remaining vacancies are for those categories where you do not fit in, I think that is not relevant at all.
not relevant. If there is somebody against those categories, they may consider their case. But well, against all these categories of vacancies, they will have to consider all these candidates who have qualification, basic qualification, then you assess the merit and accordingly you fit in their position.
Can't you de-reserve?
My lord,
Why don't you take a easy path, de-reserve and with a stipulation?
yes. I had that
See,
discussion.
900 something post, only persons are to be accommodated, not all.
Right.
This court has
And that too-
clarified that it's only for the purpose
Only
of
the
this
persons who
candidate
before the
who
court.
had come, not only confined to the writ appeal, but only for writ
Everybody who had
petitioners also.
Yes.
Everybody.
So
who-
consider them, reserve, get them and you need to bring this controversy to an
Litigation.
end. Because
that's why-
we have not heard it, but you may be in a soup. We don't know.
I will just place the stand of the department.
No, that is it. We have not heard you. You may have some very good stand, but whatever has been narrated by senior counsel, it appears that you are in a different position, difficult position. To come out of that, wriggle out of that will be difficult.
Well,
The easy stand is to reserve it, STP, whenever they will be there, you consider them.
they are, well, to
Is
my,
it permissible?
Yeah, but it will not be impermissible.
It's
It will not
there
be
is no law.
impermissible.
There
It
is
will
no
not be
law.
impossible.
No, there may be some law that you cannot reserve. You can.
I can. We
You
can, we could have done that.
So see, this option of showing vacancies, at the same time showing that these vacancies are for categories
Yeah.
where they do not fit in, will not serve any purpose.
any part.
It is an IVS. We don't like this kind of thing.
Well, this is
just
in my
Let us
response
be
to my
let us be
understanding.
very practical and let us
This is
work in an objective,
exactly.
not just for having a defense.
Just to deny these people that you went against us. Only ego satisfaction, what I feel, my lord. If I am wrong, I'll be happy. What I find is that it is only an
Okay,
ego.
then complete your argument then.
Therefore, in my response submission, my lord, they cannot say that there is no post or that our applications were subsequently taken in online. Therefore, they could not have considered. No, that will not do. Because final list was prepared. Against that, only our name should be fit in according to our merit position. And then, as has fallen from your lordship, my lord, from the last come first go basis, they will have to put it. And if they
In
can
fact,
accommodate,
that situation also they can take care
they
of.
can care of. That
They
is
can
why
take
I'm
care
saying.
of. Vacancies are there. It's only a
Vacancies are
question
there.
of
They can take
policy.
care of. They
And
can take
if you
care of.
make such a policy where you accommodate all, there will be grievance of none.
Exactly. There should not be. There should not be. And that was the assurance given initially by the learned counsel appearing for Mr. Soikia. At that time, he was not the Advocate General, but he was the.
No, we
additional advocate.
remember even in this court, we had passed certain orders that vacancies are there. Mazumdar was there.
Yes,
That will be, but this kind of situation, he will also not be contemplating.
yes,
Whatever instruction he was given, he had conveyed. Because vacancies indeed are there.
yes.
But now it's also
That,
true,
my lord,
it may also be true that vacancies are in categories where candidates are not there.
exactly.
But this situation can be taken care of.
My lord, even few days back, if I can remember correctly, another matter coming up in court number 1, the same submission was made that we have many vacancies, but there is no person to take it because we want qualified. Then the Chief Justice asked that question. Well, if these are the qualified candidates, they are coming before us, why not you accommodate them? That was this taken. And here also it was said, in this case also, when it was moved past, that no data of any state stay order, we have enough vacancies, we will accommodate. If ultimately petition is allowed. That was the understanding even I was there. Therefore, well, there is no problem at all. Provided there is a will. That will is missing as I find that. And that is only just to satisfy somebody's ego. There is no other reason I find here. And these unfortunate boys and girls in these hard days, they are litigating and coming before this court for justice and are suffering heavily. That what pains me the most. What is their fault? They are asking only for job. They are your people. They are your people. They are not the enemies. They are not the aliens from somewhere else. That is what the treatment is given. When they come before me, I feel really sorry. Man. That is the situation. Kindly see, they have gone up to Supreme Court. They have to come back again, contempt again or litigation. Where to go? We want justice from the government. Government is such a big institution. Why not? Therefore, ultimately, before your lordship, unless lordship intervenes, probably they will not get the fruit of these orders. They are all candidates with merit. That is why they are before this honorable court. And now ultimately the state government has come up with the policy that we are not holding any state tax. We are only relying on central tax. This is the latest. At that time they opposed that no, we are not relying on central tax. But court said, how can we abruptly change the course?
Now it's central tax.
Sorry?
Now it is central tax.
Yes, now it is central tax. Now they said that we are not holding any more state tax. We will only rely on and accept the central tax. Now everybody has gone back again to the central tax. See the situation of these boys and girls, our unemployed youths.
Mr. Mazumdar, they were advanced in their thinking. My lord. They knew that central tax was coming, so better to have central tax. Because state tax may be cancelled later on.
In my part, around when the state tax was not being held, one of my cousins said, when will it be held if you know anything in the department? If you have got a central tax, you go and you appear in there, you get just get a TET qualifying certificate and you apply wherever you want to. Don't wait for the state. Is what I had advised him then. And this state tax being repealed, I'm not privy to that. I don't have them. Yes,
No,
secondary tax we are doing away with.
No, in any case, the controversy being resolved by the court, and finality has come by the Supreme Court from the order of the Supreme Court. That issue, there is no question of reopening the case.
I will leave.
Anything else, Mr. Mohan?
No, my lord, that is my full submission. Lordship will kindly consider and issue appropriate orders so that earliest possible the government complies with.
See, we will hear you, but tentatively we are contemplating to make direct you to make an exercise in a time-bound manner. Either you reserve, accommodate them, or you accommodate them as per their place in the merit list, and before you do so, give a notice and fit them in. Since there are court orders, the question of principles of natural justice will also not come. Violation. Just give them a notice. First, last come, first go.
May I just with permission, or may I just suggest?
Because whether A is there or B is there,
Yes.
you are not, you don't have any inclination for Mr. Mohan or
May I just
you have to know, you need to have a qualified teacher imparting education to the student. That is your objective. And the best is the person who is above in the math. That is the consideration. And there cannot be any other consideration at this stage after the controversy of STAT or CTAT has been resolved.
No, that has been done away with.
Yes.
What had happened at page 127, I'll just, for Lordship's consideration only, it is not that I am trying to.
But
Lordship,
do not,
page
do not open up issues which have been
I will not open it.
Okay.
But I'll just place 127 for page
127.
127.
Yes.
I'll just place what the department had done and whether 127. If Lordship has page 126, the last paragraph, page 54.
in the clarification part.
No, my lord, this is the original order.
Yes.
Original order by the
What is
division.
Mr. Crafty?
Considering the fact and circumstances of the case in its entirety, in balancing the equities, we directed the recruitment process initiated by the department on the basis of advertisement dated 11/9/2020 be now processed in two phases.
Hmm.
In the first phase, appointment orders for filling up 3025 out of 3941 vacancies may be issued from amongst the stated qualified candidates. This, my lord, was done on 4th and 5th. We issued appointment letters for filling up 3025 out of 3941 posts. The appointment orders in the respect of the remaining 91 vacancies be issued to the eligible candidates in the second phase after considering the candidatures of the 916 petitioners, which includes the present appellants who are central TET qualified candidates. So the rest, the seats which remained vacant after filling up of 3025, we have simply given that calculation in the advertisement which is now under. Once we issued the 3025 letters, this is the position district wise as it has remained with us. The stand that we are satisfying an ego or we are trying not to give it to them, Lordship will find the respondents number 3 to 7, if I'm not wrong. Respondent numbers 3 to 7 had in fact applied pursuant to this advertisement. Their documents have been verified.
Over there,
Well, they have got themselves impleted because there was a stay order from this honorable court. Their documents have been verified. They have been found to be satisfying in the.
they are still.
Their state central TET.
We are also central TET qualified candidates who
Same
have advertised. After the advertisement, we applied and then a list has been prepared because we are fitting in the this reservation system. So already 133 persons name have been selected and then we have been called. We have come, our verification have everything completed. But because of an order of this honorable court,
They have not been appointed.
we are then like just like them. But our good luck is that we are fitting into some of the
You belong to those categories.
categories.
How many of you are there?
At present, 4 are before your lord, 5 are before your lordship, but 133 candidates, list of 133 candidates have been shortlisted, who have been found to be in different categories, coming in categories.
Well, that part that
I have
we
annexed
had,
that list.
we have tried to stop someone or we have.
Mr. Laskar, were you one of the petitioners in earlier cases?
Yes.
You are also a petitioner in earlier
In
cases.
earlier,
So you will fit in into this
into some of the categories.
916.
Yes.
And the stand of the department is, we have not tried to keep out someone or keep someone. What we simply did was we issued 3025 letter, appointment letters as directed by this honorable court.
Hmm.
Whoever fitted in wherever out of those 3025 candidates, we calculated, and the vacancies which remain, that is what is given on page 162, the the calculation at 20th of October 2022. Well, if the interpretation of page 127 would be what has fallen from lordship, that we now have to take into account these petitioners, see their status in the particular districts and the category as they would have stood. We are open to that interpretation, my lord, if it comes from the honorable court. But what our attempt was, 3025 were to be appointed, we appointed, posts were filled up, we cannot show vacant posts there. And therefore, they would have to be considered as a lordship will kindly have one sentence.
Mr. Malkar, you have a general select list, don't you?
An unreserved selected.
No, general. Where
For everybody, the entire merit list. Yes, yes.
some will be a particular category, there will be general unreserved category.
My lord, yes,
But you have a general select.
my lord.
Now, you want to contend that since the Honorable Division Bench has made a categorical statement that first phase go ahead with 3025 state TET
Yes.
appointment, then rest 916 appoint for the petition.
Yes.
Now, that is a procedure which has been laid down. Now, the appointments of state TET in 3025 will obviously be in certain merit position.
Yes.
Now, you have filled up you say that you have already filled up 3025 from the state qualified.
Yes.
And while considering their turn for appointment in terms of the judgment, you find that the vacancies which are now remaining are in categories where they allege that they are not fitting in. That is their problem. Now, it will be reasonable to come to a conclusion that persons whose qualifications has been held to be at par
Yes.
only because of the procedure laid down that you appoint state first in 3025, can you deprive a candidate who is otherwise superior in merit over another candidate whose qualification is at par? Question will arise.
That will arise. No,
Now, division bench, the honorable
when we-
division bench, in our humble opinion, will not mean that such appointment can be done of 3025 candidates only because they are state qualified. It is only to fill up the vacancies without any delay. You go ahead with the appointment. This, now the controversy or which the issue has arisen, that could not have been contemplated, that the vacancies which will be
And-
remaining will be of STP where none of the petitioners are STP. Now,
Lordship will
this,
have page
I think
164
this can be easily be without even
That-
interfering with your understanding
How
or
how it happens, a little understanding, my lord, perhaps be helpful to me also. When we ask for the applications from the districts, from the candidates, Lordship will have page 164 for a moment, how
Yes.
they apply.
Yes.
For them also it was made applicable originally also. The candidates who have already applied against the advertisement are requested to visit the official website of DE, log in with
no,
their
we have an
credentials.
immediate answer.
No.
Mr. Mazumdar, we have an immediate answer. Justice Saikia's order.
Yes.
That is the immediate answer. We thought about this problem. Justice Saikia had given an interim direction that even if it doesn't fit into the online, you have to put online. That you cannot wriggle
No,
out
I'm
of.
not saying about the online and offline part, my lord.
Then-
What I'm saying is the next part. Select 3 districts as per preference.
Yes.
Now, there were many candidates who had applied from the state level.
Mm.
They had also given 3 districts of their choice.
Mm.
As would be available to the repetitioners now.
Mm.
So district wise, when the select lists are made,
Mm.
a person may have applied in 3 different districts.
Yes.
He might have been accommodated in district A when he had applied for B and C also. Now, such accommodation of many persons in district A had the entire unreserved list filled up, leaving no vacancy in the unreserved category there. So it is not as if, my lord, we did not only after taking the merit
Mr.
of the
Mahanta, you had each of the
central
candidates had applied for had opted
the
for
districts
three
they want to
districts.
choose, there is no.
3 districts.
Yes, but this is their norms. We can give option for 3 districts. All can give.
But you are otherwise
No.
willing to serve anyway.
Yeah, anywhere. I need a job. They showed that you can choose 3 districts. We have given our choice.
In view of what
But
has
that is not binding.
in
on
the
us.
court, lordship will give me sometime around 16th, maybe because till 15th there are some due to independences.
See, I don't think this is an
Little
issue
time, my lord.
which really needs an adjudication. The matter has been educated to the fullest. There is maybe you call it a gray area for interpreting that part phase wise, but that will not giving a meaning,
is what the
restricted
department
meaning
has-
that we have already filled up 3025 understand, so we now cannot give.
I cannot even go beyond the.
No, that is what, that is
So
the,
what has fallen
no,
today,
that can be in your mind, we cannot express, but that you can convey that it is
my lord,
the,
so therefore, if lordship gives me some time, I had a discussion. Apparently, my lord, all of the petitioner may not fit it into the select list also in the districts.
that's
that
a
they
different
prefer.
matter.
So what I would, my lord, ask the department to do is try and find out the approximate number of persons from the list who would possibly fit in and whether they can be accommodated. And the litigation will be given a quietance. That I'll have
And
to
they are
take
willing to
the
serve anywhere.
permission of the approval of the addition of the Advocate General, Learned Advocate General also necessary. I'll place it before him and I'll have a discussion with the department to try and find out a means to bring a quietance to this litigation.
We want to finish this today.
In case lordship gives us that direction also, perhaps. Okay. In case that particular clause is interpreted to mean in a certain manner, and to consider the cases of the petitioners in that manner. Because
See,
till now, I
we
do not
don't
think they have
want to-
given
we
their
don't want to
choices.
Prolong this matter. We'll close this matter and we'll give a very viable option.
My lord.
But those options will mean to bring their grievance to an end.
Right.
And we'll give you some
My
reasonable,
lord,
we'll give you some reasonable time also.
the department has time, and again, my lord, they have tried to convince me that we are not against anybody.
That we have
People we are
understood.
fitting in, they have fitted in, we are fitting them in. There's no difficulty on that.
No, strictly
But the
going,
interpretation
strictly
comes from
going by what you are saying, you may have a point that yes, 3025 appointed, rest are in categories where they do not fit in. Where is our fault?
Even the department says that persons who have got more
But
merit
we
being
cannot
left
take
out
such a
doesn't make
mechanical
sense.
view. Interest of justice needs to be seen.
Yes,
After all, read code.
yes, ma'am.
Grievance
The-
is there, whether the grievance is genuine grievance or not, it's our duty to look out, and we find there is genuinity in the grievance.
Administration at times, the hands are bound. The honorable court, my lord, can interpret it and
Anything else will close this.
that is the stand of the
Mr.
department.
Lakhor, anything?
Yes. Since 2019, we are fighting and we are.
No, I understood, but are you within the, are you amongst the
Yes,
916?
yes, yes.
You are amongst 916.
We are among the 916 and our verification has already been completed. But because of an order of this honorable court, your lordship.
You should have said with Mr. Mohanto.
Yeah, that
Why are you sitting this
my
side?
stand is saying that we are on the same footing. So since our
How many of you are there?
3 to 7, 5,
Respondents?
number 3 to 7. Since our documents have already
You
been
have
verified.
been newly implemented.
So my prayer will be since our documents have already been verified and everything is done, your lordship, because of an order.
You
of
are
this court.
seated.
We are seated. We are all seated in it.
Then what happened? Your documents verified.
Everything done, your lordship, but because of the order of this honorable court,
Interim order.
interim order is there.
But what is your position in this select list?
That is, they have verified, your lordship. So whatever it is there, we are in the.
Okay, you are at par with the
Yes,
petitioner.
yes, prior to the petitioner. So what means that our cases may be allowed to go on. This verification have already been done. It will take some time. The other process.
But consider together.
Yes. Together, the order will take care of it.
Hard. Three, A.K. Mohanto. Open court to judge. We'll dictate the judgment in the open court, 2 o'clock.
And in case I am held up in.
No, doesn't matter. Doesn't matter.
Oh,
We
guys.
would give you the option
My lord.
with the time bound. Then even if you are, even if your present stand you are trying to maintain,
Right.
then you have the option of re-reserving. Number 2, if that is not possible on your part, then you have to find their position in the main select list,
Right.
in their category, and whatever if they fit in the select list, then you have to give accommodate by giving notice to the last part.
In case they have not yet given their choice or preferences in the districts.
They are
That
they
are
are
open.
they are willing to
We are open.
without disturbing the minimum, without disturbing the minimum possible,
My lord,
you can accommodate.
my lord. My stand in the affidavit, my lord, in the affidavit that only paragraph.
Yes.
That how we proceeded, my lord, that there
Yes,
was no
that we have
malafide or there was no attempt to
We have already.
bar anybody, my lord, that is,
stated.
I'm deeply obliged.
So much.
Deeply obliged. My juniors will be here, man.
It doesn't matter.
Yes.
No point keeping in CFB another burden.
Yes.
Request your lordship permit. Okay, I have a item number 10. Appellant's counsel, you know, he is not well. Yes, requested lordship. May I request item number 10 to fix a matter, all pending matter. On 22nd. On 22nd,
Who is the Mr. Sakia is appearing?
Your Lordship, in this matter, Mr. A.K. Gupta is appearing, Your Lordship.
He is not well.
He's not.
Not well. He has requested me also. On
Tell us any convenient date.
22nd August, your lordship kindly.
It is submitted.
Can it be
Judge
on?
Sri A.K. Gupta Lawrence counsel for the appellant is not well. However, Sri Vinod Lawrence senior counsel is present for the respondent. Para has agreed to by the parties list on
22nd,
22nd of August.
lordship. I'm grateful.
There is an interim order, Your Lordship. It may be continued.
Interim order passed earlier. Stands extended till the next date of this thing. The extraordinary powers under Article 226 of the Constitution of India is being sought to be invoked by means of this petition, which has been filed in connection with a recruitment process for teachers, for assistant teachers of various LP oblique UP schools in the state of Assam. Full stop. Before going to the issue which has arisen for determination, the facts of the case may be stated in brief in the following manner. The case has a checkered history, as there were a number of litigations, including which had gone up to the Honorable Supreme Court, and the present writ petition is an offshoot of the earlier proceeding. On 11/9/2020, an advertisement was issued for filling up 3941 vacancies of LP, vacancies of assistant teachers of LP oblique UP school in the state of Assam. The said advertisement, however, contained a condition that candidates who were Assam state TET qualified would only be allowed to participate, and central TET qualified candidates were excluded from the purview of the recruitment process. Full stop. It is the case of the petitioners that prior to that in all prior recruitment process, there was no such distinction between state TET qualification and central TET qualification. Full stop. being agreed by the state condition, comma, writ petitions were filed by the petitioners along with others which was registered as WP 3720/2020. Full stop. This court by an order dated 24/9/2020 had allowed offline participation of the petitioner, and it is submitted that in pursuance with such permission, comma, the petitioner had submitted their application offline. Full stop. The state writ petitions were, however, dismissed by an order dated 18/12/2020. The lead case being WP 4174/2020. Full stop. However, comma, the state order was the subject matter of challenge in writ appeal 24/2021, which was filed on 25/1/2021. Full stop. It is submitted that the Honorable Division Bench had made an observation that no interim order was required, as the statement was made by the Senate Council representing the department that due consideration would be made. Full stop. Subsequently, comma, by the order dated 3/2/2021, comma, the writ appeal was allowed. Full stop. It is, however, clarified that amongst the 916 numbers of writ petitioners, comma, the same included 581 candidates who had applied under the Director of Elementary Education and 335 candidates had applied under the SSA. Full stop. Since there was some clarification, there was a requirement of some clarification, comma, on the very next date of passing of the judgment, comma, the petitioners had filed IA number 258/2021 on 4/2/2021, in which time was taken to file objection by the department, which was ultimately done on 11/2/2021. Full stop. On 12/2/2021, comma, the matter was taken up for consideration, and the last paragraph of the judgment dated 3/2/2021 was clarified to mean that there will be no ambiguity in the direction that the petitioners who are central TET qualified are to be were directed to be considered. So, the order of the Honorable Division Bench was unsuccessfully challenged by the department in the Honorable Supreme Court by in SLP number 9032-9033 of 2021, and the SLP was dismissed on 3/9/2021. Full stop. In the meantime, comma, the petitioners had, after waiting for a long period of time, had instituted contempt case number 296 of 2021, in which notices were issued. Full stop. Thereafter, on 4/5/2022, an advertisement was issued specifically mentioning that it was meant for the writ petitioners in the petitions which were filed in connection with the advertisement dated 11/9/2020. Full stop. The advertisement public notice dated 4/5/2020 had directed submission of application online, which the petitioner had accordingly done. So there is a further notification dated 25/5/2022, whereby the department has clarified that the process was to verify or assess the position of the candidate in the select list. Full stop. However, on 28/10/2022, a notification has been published giving the breakup of vacancies. Full stop. From the state breakup, which are given in a tabular manner, vacancies were mainly existing in SP Hill and SP P category, and the petitioners were mainly in the categories of OBC, MOBC, SC, and unreserved. Full stop. As a result, the scope of a due consideration has been extinguished, resulting filing of the present petition. Full stop. Para. I have heard Sri K.K. Mohanto, Senior Counsel, assisted by,
K. Mohanto and N. Begum.
by MS K. Mohanto and M. Begum.
N. Begum.
And Begum. I have also heard Sri R. Mazumdar, Standing Counsel for the Elementary Education Department. Full stop. Sri M. H. Raskar, Learned Counsel, is present for the responsibles 3 to 7 who were subsequently impeded in this writ petition. Full stop. Sri Mohanto, the Learned Senior Counsel, has submitted that the initial writ petition was instituted in the year 2020, and in the long proceeding which had even gone to the Honorable Supreme Court, the issue of lack of vacancies in the categories in which the petitioner belonged was never taken up. Rather, it was always the intent of the department in the court that the cases of the petitioners could be considered. Full stop. It is further submitted that ambiguity, if any, in the judgment dated 3/2/2021 of the Honorable Division Bench was clarified by the subsequent order dated 12/2/2021 of the Honorable Division Bench, which was passed after filing of the objection by the department. Full stop. It is submitted that the aforesaid that the present issue not being raised at any prior point of time cannot stand in the way for proper proper implementation by giving a logical interpretation to the order and direction of this court. Full stop. Para. The senior counsel, by referring to the affidavit in opposition of the Director of Elementary Education, Assam, filed on 24/7/2023, has submitted that a statement has been made that on 5/2/2021, the recruitment was completed, and therefore the department could not be faulted with taking up the present stand. Full stop. He submits that such statement could not have been made in view of the ongoing proceedings and also in view of the notice dated 25/5/2022, whereby it was notified that the position of the petitioners would be verified public access in the select list. Full stop. The senior counsel accordingly submits that a consequential direction is required to be given by for offering the appointment to the petitioners depending on their position in the select list. Full stop. Para. Sri R. Mazumdar, learned standing counsel of the department, opposing the stand of the petitioners, has drawn the attention of this court to the judgment and order dated 3/2/2021 passed by the Honorable Division Bench, in which there was a direction to make the recruitment in two phases, and in the first phase, 3025 numbers of state qualified candidates were to be offered appointment. Full stop. He submits that pursuant to the said process of appointment, the remaining vacancies in remaining 916 vacancies had remained, and those are mainly in the category of ST Hill and STP. And for that, the department cannot be faulted upon. Full stop. He submits that a candidate could have given option for, could have given preference for 3 districts, and by following the state procedure, the vacancies in the categories in which the petitioners belong have been filled up. Full stop. He accordingly submits that there may not be any cause of action in this petition. Full stop. Sri Laskar, Sri M.H. Laskar, and counsel for the response number 3 to 7 has submitted that the said respondents are also centrally TET qualified candidates whose documents were verified in the meantime and only because of the interim order passed by this court in the present case, their appointments are held up. He accordingly submits that that the cases of the state respondent 3 to 7 may also be considered by this court. The tribal submissions made by the learned counsel for the parties have been duly considered, and the materials placed before this court have been carefully examined. Full stop. The principal challenge with regard to exclusion of central TET qualified teachers, central TET qualified candidates have already been resolved by this court and also affirmed by the Honorable Supreme Court by the order dated 3/9/2021, whereby the SLP preferred by the state against the judgment and order dated 3/2/2021 of the Honorable Division Bench in the writ appeal has been by Department, state has been affirmed. Full stop. Therefore, as on date, there cannot be any distinction between a central TET qualified candidate and a state TET qualified candidate who are the advertisement dated, who are the recruitment process initiated by the advertisement dated 11/9/2020 is concerned, and all such candidates are to be treated at par. Full stop. This court This court has also taken note of the fact that that the department cannot even take the stand that the application of the present petitioners were not submitted within the prescribed date, as this court by the interim order dated 24/9/2020 had allowed such participation offline by the present petitioners. Full stop. Para. Sri Mazumdar has taken the point that the division bench in the judgment and order dated 3/2/2021 had however made an observation that the recruitment is to be done in two phases. And in the first phase, 3025 numbers of state TET qualified candidates were to be considered, and thereafter the remaining 916 vacancies are to be filled up by the petitioner. Full stop. Though it is submitted that while making the state recruitment, the remaining vacancies are of categories in which the petitioners do not qualify, such submission made on behalf of the department cannot be sustained for more than one reason. Full stop. Since in the earlier proceedings it has been held that there cannot be any distinction between centrally TET qualified candidates and state TET qualified candidates, the state direction, the state observation to make appointment of 3025 state TET qualified candidates in the first phase was given only because of the urgency to fill up the post, and the remaining part of the observation to consider the appointment of the petitioners for the 916 numbers of vacancies cannot be made redundant by the present stand of the department that vacancies are only available in such categories of mainly of ST Guild and STP, in which the petitioner cannot be considered. Full stop. In any case, the appointments are to be made strictly in accordance with merits on the basis of their position in the merit list. Full stop. Though the advertisement, though Sri Mazumdar, the learned department counsel, may be correct in contending that there was a stipulation to give preference to three districts, this court is of the view that the same would not mean that a candidate who is willing to serve in any other district cannot be can be denied of such appointment. In any case, Sri Mahanta, the senior counsel, has clarified that the petitioners are ready and willing to serve in any district of the state. In view of the aforesaid discussion and the background facts and circumstances, this court is of the opinion that a case for interference is made out. This court, therefore, is of the opinion that the following directions would serve the interest of justice and also the equities can be balanced. The state would have the option to carry out an exercise for re-reserving the numbers of posts in which the present petitioners are required to be considered in accordance with the earlier direction of the Honorable Division Bench in the judgment and order dated 3/2/2021 with a stipulation that such reservation would be later on filled up in subsequent recruitment process. The said exercise, however, is to be completed. The said exercise, if decided to be undertaken, is to be completed within a specified period, preferably, period of 3 months from today. The state, if the aforesaid option is unviable or not able to be complied with by the state, the the respondent authorities who are directed to assess, to offer appointments to the petitioners after consideration of their position in the select list. And if any of, if, and for those petitioners whose position are above the last, are above any candidate who are below, who have been offered the appointment, the last of such candidate should make way for the appointment of the petitioners. Full stop. The aforesaid exercise, however, is to be done by issuing a notice to the affected candidate, and appointments that be offered to the petitioners strictly based on their position in the select list prepared in pursuant to the initial advertisement dated 11/9/2020. The entire process is to be completed within a period of 3 months, as the recruitment process was initiated in the year 2020 itself. Petition accordingly stands
Petitioners
adopted.
along with respondent number 3 to 7,
Only candidate.
that can be included.
Petitioners along with respondent.
Number,
Petitioners are not similarly situated candidates,
including respondent number
including respondable
3 to
3
7.
to 7. The petition accordingly stands allowed.
Oblige.
Yes,
President.
appeal is maintainable.
Yes, under section 24. It is maintainable in various High Court has observed.
Which paragraph?
Paragraph 40, 40.
No, this is under the family code. Family code matters is slightly different. Let us see the family code. 91. See the previous paragraph, paragraph 39. Some of the learned counsel expressed their apprehension that it will result in an anomaly if this court holds that an order made under section 24 of the Hindu Marriage Act by a family court is appealable, whereas similar order made by a civil court, means the district court, is not appealable. In this regard, we need to be mindful that an appeal is a creature of statute. Of course, it is true that the Hindu Marriage Act does not provide for appeal against such order, whereas the family court provides for such. And this is not under the family court act.
Yes. This is civil
It's
court.
under the civil,
Civil.
under the, your appeal is under 28. And this we cannot help because, as you know, the same decree passed by a family court will be heard by a division bench. And if it is passed by a district court,
Yes.
it will be a single. bench.
Single bench. Yes.
The same function there, it is being exercised, but the statute is different.
Yes.
You may be knowing for your information, only 6 districts are having family court.
Yes.
And rest out of 34, isn't it? Those are having district judges
This is
functioning as almost family court doing matrimonial.
matrimonial dispute. Yes.
So these are matters of statute. We cannot, there is no question of any interpretation. You file it as a revision.
Lordship, in 41's, in this judgment, register is directed to
The conversion of a revision into appeal is slightly difficult, but from appeal to revision, I don't think it is difficult. We treat this as a revision.
register, it can be converted to
A revision.
Yeah.
When is the next date?
it is 14.
14. Why don't you find something else? And there may be something else in your favor.
Lordship,
There may be some case laws in your favor.
there is Bombay High Court is Madhukar. I have no printout there in the mobile. I could not collect the
Give us the citation. Give the citation, we'll write. Where did you get it? No case number. Case number is there or not? We'll do one thing. We'll take up this matter tomorrow day. We also explore, we'll try to see if
yes.
there is any provision where appeal is mandatory. Otherwise, adjudicating is not a problem for us,
Yes.
but the procedure, whether it be appeal or
Yes.
only. 14th you have said next date.
Yes.
We'll have the afternoon. Day is what? On 10? On the prayer made on behalf of the appellant. List on 10. We'll also try to.
Highly obligation.
This we are retaining will after tomorrow we'll get it. Yes. Arrested.
Samaja. This is the appeal against the appellate decree passed by the learned civil judge Borpata, reversing the judgment and decree passed by the learned Munshi Borpata, my lord. The present respondent has plaintiff has filed a title suit before the learned
Just
Munshi
a minute.
and
Better
the
description. Just appellant is the defendant.
Yes. Appellant is dependent and respondent was the plaintiff. The
Appellant is the defendant. How many appellants? One appellant. Defendant, okay. Suit
The-
for,
final
suit for,
truth for declaration, plaintiff matter page 37.
suit for,
Should for declaration of right title interest on the A schedule land, my lord. And the also declaration of right title of the B schedule land, which is the part of the A schedule land. My lord, I may be allowed to read the head of the plain. That the A suit for it is page 37.
your vote for A schedule and B schedule.
Actually, they have plaintiff has for declaration of right title interest of his himself and the defendant and the performer defendant in respect of A schedule land, my lord. That means the plaintiff has admitted the title of the defendant in their land, my lord, A schedule land. And out of the A schedule land, there is there is a 2 bighas of land, which is shown in a B schedule land, my lord,
Within A,
within A, my lord,
how much is A?
my lord.
How much is A? What is the area of A?
Area, my lord, the B schedule, in the B schedule land, only
No, A.
A schedule, my lord. A schedule, I am coming to the schedule of the plain. A schedule, my lord, a plot of land measuring 6 bighas 2 kotha 14 lusa, covered by diag number 213, 213 whole 2 kotha 2 bighas 1 kotha 15 lusa, and 215 1 bighas 3 kotha 17 lusa, and in 214 1 bighas 2 kotha 2 lusas under the periodic quota number 40 of place so and so.
Okay, and schedule B,
Schedule B is the only a plot of land measuring 2 bighas 18 lusas, 2 bighas 18 lusas out of the A schedule land.
Okay.
But in respect of that is admittedly, this is the part of the A schedule land, my lord. And plaintiff himself has sought in the declaration of right title of the himself and the defendant and the performer defendant, my lord. That means the defendant has the defendant present appearance has the interest on the A schedule land, my lord. The title. And the B schedule land, my lord, there is neither drag number nor quota number nor boundary, my lord.
what is the source of right of the plaintiff which was being espoused?
My lord,
What was the source of his right to the land?
according to plaintiff, this land belonged to the entire land belonged to his father, his father of the defendant, and also
The defendant and plaintiff are brothers.
brothers, plaintiff, same family, my lord, there. The performer defendants and they are possessing the land, my lord. Now the main point is, my lord, admittedly the
The land originally belonged to your father.
yes, father.
What is his name?
Sagor, I am to read out the plain. The plain, my lord, page 38. The what?
20 back to study, a plot of land measuring 6 bigha 2 kotha 14 lusa is covered by diag number 213 2 bigha 1 kotha 15 lusa 215 1 bigha 3 kotha 17 lusa and 214 1 bigha 2 kotha under the periodic quota number 45 of Blake Shakti Bari, Moja Betabari, district Borpeta, Assam stand in the name of the plaintiff, main defendant. That means the present appellant major. It is page 38. Okay. And also pro forma defendant, my lord. In the name of the all this person. Formally, this said land stood in the name of the Potada, namely Kutubuddin, Wahed Ali, Samad Ali. Samad Ali means the father of the present appellant, my lord. Samad Ali. Samad Ali and Moti Ali, Asghar Ali, the father of the plaintiff, and the Siku sex. The said 6 bigha 14 lusa of land, more specifically described in the schedule A of the plain, my lord. That means the father of the defendant was also one of the Potada, my lord, shareholder. And the father of the plaintiff also, and father of the pro forma defendant, my lord. Then belong to them. They were brothers. Yes. That means they had, all of them has a title in the schedule land, my lord. But he also pays for declaration of right title.
What is the name of your father?
My lord?
The name of your father?
Sagar Ali, my lord. Dependents. Samad Ali. No. Samad Ali is the now appellant.
Your father is Abdul Basir.
Yes, not father. No, Samad Ali led Abdul Bashar. Samad Ali is the dependent, my lord.
Yes, Samad Ali, you are representing Samad Ali. Your father is Abdul Basir.
Abdul Bashar, my lord.
Abdul Basir and Asghar are all
Asghar
brothers
Ali.
and Wahab.
All of them has interest in the share in
You give us the family tree, that will be easier for us.
president.
Who is the original owner?
My lord?
Give us the family tree, it will be easier for us.
Okay.
Who is the original owner of the land?
Who is the original owner as per this plain? As per this plain, my lord, original owner is the name of the Potada Singh Kutubuddin, Wahed Ali, Samad Ali, the father of the defendant, Moti Ali, Asghar Ali, the father of the plaintiff, and the Siku sex. These are the original Potada of the land.
Six owners originally.
It is in the para one
Six
of the
owners.
para one of the plain, my lord.
Yes, 6 numbers. 6 numbers of Patadas.
Yes.
Okay.
Now, my lord, this said 6 Patadas were entitled to get 1 bigha 9 lusa of land in the out of the A schedule land, and they had been possessing, possessed their respective portion. The deceased father of the plaintiff Asghar Ali, and his brother Sheku Sheikh jointly possessed after 3 bigha 18 lusas of land out of A schedule. Said Sheku Sheikh died and before his marriage, leaving behind the father of the plaintiff as the sole legal heir. Hence, the said Sagar Ali enjoyed said 2 bigha 18 lusa of land out of A schedule land as A schedule till his death. In the meantime, Sagar Ali also died, leaving behind the plaintiff as his legal heir, and the plaintiff had been possessing the said 2 bigha 18 lusa of land out of A schedule till 19/4/2002. This said 2 bigha 8 lusa of land specifically described as schedule B of the plain. According to my lord plaintiff, that 2 bigha 18 lusa of land was trespassed by the present appellant respondent in the year 2008 to bring the cause of actions of the suit. Actually, all 6 bighas of land was jointly possessed by them, having their title on it, my lord. And that the former Potada of the suit potter, namely Moti Ali, had title and interest over 1 bigha of land out of 1 schedule, and his sole entire land was in favor of Kutubuddin, this father of the pro forma defendant number 3, but the revenue authority has mutated the name of the state Kabiruddin over 3 bigha 3 kotha 15 lusas of land out of A schedule land on 23/11/67, which is expressed 2 bigha 6 lusas of land. The mutation order is highly illegal, inoperative, and void in law, said Abiruddin possessed 1 bigha 9 musas of land out of a civil land where from the sold 1 bigha 5 musas of land in favor of Imam Ali. The proforma defendant number 1 and the rest portion of the 4 kota 4 musas of land possessed during his lifetime and after his death. The proforma defendant number 3 has been possessing the state 4 kotas of land out of the ACBL as the sole heir of the late Kabiruddin. The main defendant sold 4 kotas of land in favor of Bantapati Nesa out of his sole share of 1 bigha 9 musas of land out of ACBL and handed over possession in her favor, and accordingly she possessed her state 4 kotas of land till the death. After death of Bonaparte Nesa, her son namely Abdul Jalil, Hatimuddin, Kaminuddin, Nizamuddin, Ikamanuddin, and Tajimuddin possessed 4 kotas of land by inheritance. Later on, these 6 brothers sold their 4 kotas of land in favor of the Asma Ali and handed over the possession thereof. Later on, the proforma defendant number 1, Iman Ali, purchased 4 kotas of land from the state Amsar Ali and 1 bigha 5 kotas of land from Qatibuddin, and the revenue authority mutated the name of the proforma defendant. Proforma defendant number 1 over 1 bigha 5 kotas of land out of ACBL land again said Imam Ali purchased 1 bigha 5 kota of land from Abdul Samad and has been possessing totally 1 bigha 1 kota 5 kota of land, ACBL land. Similarly, P.T. Potadar Wahab Ali possessed 1 bigha 9 kota of land out of ACBL during his lifetime, and after the death of proforma defendant number 2, Nawab Ali entitled over the 1 bigha 9 kota of land by inheritance. The Patadar Kutubuddin had also entitled to 1 bigha 9 kota of land out of the suit property. Later on, State Kutubuddin sold 3 kotas of land in favor of the Abdul Torim and Sarumia out of his share and handed over the possession thereof again the State Kabul Torim and Sarumia relinquished their share in favor of the main defendant. That the main defendant has been possessing totally 3 kota 4 lusas of land out of the suit land, and the plaintiff had been possessing the BC dual land. The main defendant has no right, title, and interest over the BC dual land out of, but suddenly on 2008, the main defendant forcefully and illegally trespassing dispossessed the plaintiff from 1 bigha of land and occupied. The plaintiff requested the main defendant to vacate the main civil land and continuously, but he denied to vacate in favor of the plaintiff. Hence, the plaintiff are bound to bring the suit for declaration of right title the interest of her civil land and for recovery of the possession over the suit land. The cause of action for the suit, so and so the suit is valued at demand. Now, the pair portion is important. The pair is it is therefore declared that the plaintiff, the main defendant, and proforma defendant have the right title interest on the ACBL land, my lord, including defendants, my lord, representative land. And secondly, declare that the plaintiff has right title and interest over BCBL land. If all the defendants, plaintiff and proforma defendant have their title on the ACBL land, and how defendant can claim his title over the BCBL land, which is the part of the ACBL land, my lord. It is not separate land, it is ACBL land under quota number so and so. But in the BCBL land, there is no DAG number, no quota number, no boundary, my lord. Only 2 bigha 18 lusas of land. The specification of property, I'll come order 7 rule 3 of the CPC has clearly stated. Order 7 rule 3 has clearly stated that order 7 rule 3. Order 7 rule 3. order 7 rule 3 my lord CPC. Where the subject matter of the suit is immovable property. Where the subject matter of the suit is immovable property, the plain shall contain descriptions of the property sufficient to identify it. And in case such property can be identified by boundaries or numbers or in a record of settlement or survey, the plain shall specify such boundaries or number, my lord. It is clear, my lord. In the B schedule land, there is no boundary, no tag number, no photo number. Photo number, suppose it is under photo number 45, my lord. But there is no boundary, no tag number. So it is completely violated order 7 rule 3 of the CPC, which lays down for specification of the property the must. To that effect, I'll satisfy your lordship with a decided case law. Now the pair is, my lord, a declaration that the plaintiff has right actually interest of B schedule land. Declare that the main defendant is the mere trespasser over the B schedule land. If it is said that the defendant, the main defendant is also one of the co-possessors of the A schedule land and he is possessing that, then how he can be trespasser in the B schedule land, my lord? The plaintiff himself has sought declaration for himself also in respect of A schedule land. And the B schedule land is a part of the A schedule land. Now, how the defendant can be constructed as the trespassers in the B schedule land, my lord? Declare that the plaintiff are entitled to get partition of our B schedule land and accordingly issue receipt to the revenue authority to they have also kept partition. To be partitioned, there may be specification of the property, my lord. Under which tag number, under which boundary the land situated, my lord. If the specification is there, then the partition can be done. Because in respect of partition, it requires both title and possessions, my lord. And the specification of the property. As there is no specification of property, how partition can be? Because a schedule land land consists of 3 dags, my lord, 4 dags. Under which dag these 2 bigger land falls, my lord. That is not there. So if the decree, London municipal rightly dismissed the suit as vague, it is a plaintiff's vague, but because if the decree is passed, it is not executable decree. Decree should always be an executable decree. As per order 21, the decree must be capable of being executed, my lord. So where there is no boundary, no tag number, no photo number, nothing else, how it can be executed, my lord. Now the issue permanent injunction, etc. The decree or the cost of the suit, decree may be in relief to so and so. So that is the respective submission, my lord. The B schedule land is the vague. There is no tag number, photo number, boundary as per requirement of order 7 rule 3 of the CPC. And if the case passed by the learned appellate court in respect of that land, it is not an executable decree, my lord. Now the my lord, let us come to the judgment passed by the learned municipal, my lord, or who has discussed all these things, my lord, properly. Page, I'm coming. Page, my lord, start from page 22, my lord. Oh, this will know. Page 20, my lord, start. This is a suit for declaration. Declaration, recovery of possessions and partition. The plaintiff. Mr. Sharma. My lord. Page 20. Thank you. Thank you. Kindly turn over the pages. Kindly turn over. Turn over the pages. Kindly turn over the page. It is 21, my lord. Thereafter, turn over. Turn over the pages. Oh, yes. Oh, it is. You don't take that much of care. It is by a petitioner at the time of filing the suit not properly. You don't take that much of care. It will be. How can we help you? My lord? You take that much of care in filing. It will stay again. We'll have it after tomorrow. Rectify it. Don't do it yourself. Ask your junior. Don't do it yourself. Ask somebody else. Should be good. Not only one thing. We'll have it day after tomorrow.
Day after tomorrow.
But ask your,
I'll make it clear. No. Make it part of.
do it in the court itself. Inside the court.
I will do it here. Day after tomorrow part of.
Not part of it, we'll have it day after. Talk day after tomorrow. Pages are all in the reverse order. Has to be, everything has to be opened.
I'll do my part tomorrow, my lord, let him complete.
Will he be able to be completed today? Do you think?
It will, no, it will not be complete.
Even otherwise, you cannot do it today. Now we don't want to continue with the other matters. Some discrepancies come with the pages. There was no chance for your matter today, but you are in luck, it seems. No. At the time of hearing. Some so, current count. Rectify. The same may be done in the courtroom itself. The matter. You bring your card, Mr. Sharma. Don't do it yourself. Some stitching would be required. Yes.
My lord, this is second appeal, my lord. On the concurrent pending, the case is regarding part performance of contract, my lord.
Part performance.
Yes, ma'am. On the basis of a document, which is a hand of my lord. The exhibit 2, my lord. And it's first finally see the my lord, exhibit 2.
You're invoking 54 of the TPI.
Yes, my lord.
54.
Yes, ma'am.
You are the plaintiff,
I am defendant.
defendant.
Yes, ma'am.
Who decreed?
Suit was decreed against.
Appellate court affirmed.
Affirmed. The substantial question, my lord. Whether the learned court below committed errors is considering exhibit 2 agreement for sale. So only one substantial question. Liberty is given to any other
Appellant is the defendant. Suit for
specific performance of contract.
contract.
Yes.
Yes.
Well, first, your lordship, going to the exhibit 2, my lord. This is the document.
First, tell us the fact, a little bit of fact.
Fact, my lord,
There was an agreement.
there was an agreement. He was a tenant, my lord. He plaintiff was a tenant. He is running a garage, my lord, in my land, my lord. Subsequently, my lord, Our case is that he obtained a signature in a blank page, my lord, for taking loan in the bank, my lord. And he converted it as a hand note, my lord. It is a hand note. He has stated that it is a hand note. This is the exhibit 2, my lord. And the code below treated as a contract for sale, my lord. This document hand note.
What was the hand note?
Hand note is exhibit 2, my lord.
So what is it? What is the quarterly
In
contract?
toto, my lord, it is like a contract, my lord. And that is accepted by the board, the code below. My lord, I am reading the one page, my lord, one page, exhibit 2 is only one page.
Yes.
I am reading, my lord.
Okay, where is it? Page,
In except 2, my lord,
page,
in record, my lord, and except. Very bad. C5. C5.
exhibit 2.
Exhibit 2, my lord. May I read, my lord? মই শ্রী হিমেন বৰঠাকুৰ, পিতা নাম শ্ৰী শ্ৰীনাথ বৰঠাকুৰ, নিবাস টিআৰ ফুকন ৰোড, যোৰহাট, পেছা ব্যৱসায়। আজি 8/4/2009 তাৰিখে সুস্থ মগজৰে শ্ৰী পুলকমণি শইকীয়া, পিতা সোণাৰাম শইকীয়া, নিবাস টিভিচৰণ বৰুৱাৰ পথ, যোৰহাট, পেছা ব্যৱসায়, নগদ 2 লাখ টকাৰ একচুৱেলি প্ৰাপ্তি যদি প্ৰাপ্তি স্বীকাৰ এই ৰচিদৰ দ্বাৰা কৰিলোঁ। এই টকা মই মোৰ মালিকী স্বত্ব থকা মেডি 7 নম্বৰ 62 নম্বৰ ডাক 46 আৰু 83 নম্বৰ ব্লক নম্বৰ যোৰহাট টাউনৰ মৌজাৰ অন্তৰ্গত 1 বিঘা 17 আচাৰ মধ্যৰ দক্ষিণ পূব দিশৰ তৰাজন নদীৰ ফালে এক কঠা অংশ শ্ৰী পুলকমণি শইকীয়াক বিক্ৰী বন্দোবস্ত সংক্ৰান্তত আগধন হিচাপে, আগধন ইজ ইম্পৰ্টেণ্ট মেলত হিচাপে গ্ৰহণ কৰিলোঁ। এই সংক্ৰান্তত যাৱতীয় আইনমতে দলিল আজি অতি সোনকালে মই সমাধান কৰি দিম বুলি it is actually it is written as অস্বীকাৰ মেলত, this is অংগীকাৰ, it should be অংগীকাৰ মেলত, অংগীকাৰ কৰিলোঁ। This is the document. Here মেলত this 2 lakhs rupees is advance money. There is no money fixed for the total consideration. It is advance money, my lord. 2 lakhs is advance money, agdon. And no total consideration is mentioned here, my lord.
Yes.
And thereafter, my lord, exhibit 3. This is a notice, trigger notice. Never we have not received that notice, my lord. We have not received that notice, exhibit 3, my lord. In that notice, my lord, there it is stated that on 849 executed a document and received a sum of rupees 2 lakhs only as advance from my client for sale of a part of land out of the total land so and so. 1 bigha 70 lesa, the southern side of so and so. So this is the advance money. It is reflected in this their trigger notice. This notice we have not received, my lord.
Yes.
And my lord, as per annexure 2, my lord, description of land is, my lord, Dag number 62, Pata number 62, Dag number 46 and 83, my lord. But they claim in their suit in one Dag, my lord. In plain, my lord, this 33. 40 मतलब. Land measuring 10 lessa. As per my lord, that exhibit 2 my lord, it is land one kotha. It is 1 kotha and they claim 10 lessa. Land measuring 10 lessa out of total land measuring 1 bigha 7 lessa, covered by diagram number 83 of clear periodic number 62.
Where is the land, measurement of the land in exhibit 2?
Exhibit 2 is there, my lord. My lord, মধ্যৰ দক্ষিণ পূব দিশৰ yes, মানে 1 বিঘা 17 লেছাৰ মধ্যৰ দক্ষিণ পূব দিশৰ পৰাজন নদীৰ ফালে 1 কঠা অংশ টিপুলক মানে so it is 1 কঠা মেল out of 1 বিঘা 17 লেছা. And there is 2 dark mill. There is 2 dark. One is 46, one is 83. And my lord, in exhibit 1, the Zomabandi.
Yes.
In my Zomabandi Melod, there are 2 dark Melod. Patta is 62. 1 dark is Melod 46. And in 46, there is only 10 lessons of land. And 83 dark, there is 4 kotha, 17 lessons. So they claim in the dark number 83 in the Suk Melod. Although written the document Melod, the hand note, it is written 2 dark Melod. They claim only 1 dark Melod. And Melod in this exhibit 2, there is no boundary. There is no specific boundary, but that
These witnesses were examined.
examined. Melod, 2 witnesses examined. One supported the plaintiff. Another supported our case because he was not present at the time of signature of the blank paper. Our case is that they obtained signature in the blank paper.
Yeah, all the 3 witnesses, they.
I think 2 witnesses.
So there are 3 witnesses in the exhibit 2. All were all had deposed in the proceedings.
Yes, Melod. In 3 2 as on plaintiff, 1 is the plaintiff. 2 witness Melod. Apart from the plaintiff Melod, 2 witnesses are there.
What is the name of the plaintiff?
Pulokmani Soigan.
No, we are on the. Have you got exhibit 2? I mean, yes, an exhibit 2. Exhibit 2.
Exhibit 2.
The hand note.
Hand notes. Ora Jyotipurian. Ibu Pustakakan. Ora Jyotipurian. Zakir Hussain.
But all of them have exhibited. Zakir Hussain, what is his name? Zakir Hussain Bhaiya.
Yeah, my lord.
Zakir Hussain Bhaiya. And for us, Jyoti Borua is there.
Yeah, my lord. Zakir Hussain on cross mailer, short cross mailer. He has stated he was PW3. Zakir Hussain is PW3 on cross. He has stated that মই মোৰ হাইট কৰে ভিডিঅ'ত কি লিখা আছে নাজানো বাদী মোৰ বন্ধু হয় বিবাদীয়ে বগা কাগজত চহী কৰাৰ সময়ত সাক্ষী হিচাপে নাছিলো our claim is that we have put our signature was taken in a blank paper white paper কাগজখন লিখাৰ পিছত মই চহী কৰিছো এইটো সত্য নহয় যে মই বন্ধুৰ খাতিৰত মিছা হাইট কৰিছো এইটো সত্য নহয় যে মই বাদী বিবাদীৰ মাজত হোৱা কোনো পইচাৰ লেনদেন দেখা নাছিল so he has not present at the time of signature.
This, who has said this?
It is Zakir Hussain.
Zakir Hussain.
Zakir Hussain, PW3 minute.
Zakir Hussain, PW3.
3 minutes.
And what was the consideration for the learned court?
But yesterday it is not a hand note, it is an agreement for sale. And it is proved by witnesses. Proved by witnesses, then that's a specific performance was granted. Both they got concurrent finding.
Let us see the finding. Last part.
Yes, ma'am. Page 10.
A has not been invoked for performance.
Madam, they are in position as a tenant, my lord. They have not
No,
disclosed,
they were the plaintiff.
they had a plaintiff. My lord.
They had said that already one amount was given to you in advance,
Yes, ma'am.
and they were ready and willing to perform the rest of the
Because-
contract.
My lord, there is no consideration money was fixed, my lord. It is advance money. This is the main point, my lord. 2 lakhs rupees given as a advance money in the document exhibit 2 itself and the notice issued by the advocate. My lord. It is a advance money, but what is his total consideration? It is not there.
Just a minute, let us see the print. How has it been structured?
He has not made a single whisper regarding his position as a tenant, my lord. But in a cross examination, he has stated that I was tenant in the particular plot of land.
Yes, sir.
Plain is at page 33 minutes. That para one I'm reading, Miller, that a plot of land measuring 10 lessons out of total land measuring 1 bigha 17 lessons, covered by DAG number 83 of Kiraspiradi Patna number 62, situated at block number 04, Jorhat town, Moja, in the district of Jorhat, is the subject matter of this suit, and the land is more fully described in the schedule of the plain and hereafter referred to as the suit land.
my lord, this particular paragraph 1 does not tell you the exhibit 2, my lord. This is not the only there are 10 lessons, my lord. It is 1 quota, my lord. Not 1 because 70 lessons to 10 land, my lord. And DAG number is not only 83, there is another DAG also. Patta number is 63, this is correct, my lord. Then, my lord, that the defendant is the absolute owner, who is the absolute right title, interest and possession of the suit land, and being his need of money, express his desire to sell the suit land, and if 20%.
What are your grounds?
My lord, grounds, so one ground is that it was, we have not made any agreement, my lord. Like
No,
that,
no, grounds of, in this appeal, taken
my lord.
whether the court below committed error in considering exhibit 2 agreement for sale.
Yes, ma'am. All along, he has stated that it is a promissory note, my lord.
So his description or nomenclature will not make
Substance,
of a difference.
substance will do, my lord. Yes,
yes, but you are correct in the train. He has started with that line,
yes, ma'am.
that hand note.
And note. Anyhow, my lord, even if it is a hand note also, if the substance is an agreement, my lord, it can be considered. But my lord, it is in the particular
But the connotation of a hand note is totally different there with an
different, my lord, different.
hand note
because-
is only with regard to certain money,
Money or either it can,
which has to be returned.
yes, ma'am, there is.
Now here, he has termed it to be hand note.
Yes.
But the consideration appears to be something else,
Yes,
as if it is an advance
yes, ma'am.
for the land in question.
Yes, ma'am. But with the description of the consideration money, it is advance money, my lord. There must be a consideration amount of the sale. Full consideration, that is not there, my lord. In notice itself, my lord, that is the advance money. Agreement also, it is advance money act on. And the boundary is not there. DAG number, pata number have been sensed in their plain, my lord. Agreement is different, my lord. And the amount 2 lakhs, my lord,
Boundary is also not there.
not there. And my lord, even if it is considered that it is 2 lakhs rupees, my lord, at Jorhat town, it is a hardship that there cannot be the 2 lakhs rupees for 10 lessons of land. It cannot be a full consideration, my lord. It may be advance, my lord. So although we have denied that we have not received any money, we have not signed any hand note, nor agreement for sale. And they have stated that the document itself written by me, my lord, but they have not examined. We have denied, my lord. They did not examine the hand note department. regarding writing, my lord. Signature, we have stated that we have put signature in blank paper. But regarding handwriting, they have categorically stated you have write yourself that document. But they should have come with a handwriting expert, my lord.
What about the revenue stuff?
Revenue stamp, my lord, it is stamp package there, my lord. There is also on ground, my lord. Stamp package. The stamp is required in the hand note, my lord, not in the agreement, my lord. There it is, they have put a stamp, my lord. And my lord, whole pleading plain, my lord, they never whisper about their tenancy in the particular plot of land. Not a single word, my lord, that I am tenant, my lord. They
No. Why is it required?
is required, my lord. This is particular, this land, he was as a tenant, my lord. Our plea is that he was tenant.
No, that is your plea.
They have admitted, my lord. He has admitted in evidence. I am reading, my lord, short. I am reading this evidence, cross evidence. But he have not, neither in their notice, my lord, nor plain, not a single word that I was a tenant, my lord. মোৰ এমাজনছো বুলি এটা ফেব্ৰিকেশ্যন ইউনিট বিবাদী মাটিত আছে। মই ইউনিটটো আৰম্ভ কৰা 4 বছৰ হৈ গৈছে। 2004 চনত মই প্ৰতিষ্ঠানটো প্ৰতিষ্ঠা কৰিছিলোঁ। তো এগ্ৰিমেণ্ট ইজ মেলত 2011 না 2009 মেলত। ফেব্ৰিকেশ্যন ইজ ষ্টাৰ্টেড 2009 মেলত। সেই মাটিত প্ৰতিষ্ঠানটো আৰম্ভ কৰিছিলোঁ, সেই মাটি বিবাদী বৰঠাকুৰৰ মাটি আছিল। মই সেই মাটিত ভাড়াতীয়া হিচাপে প্ৰথমে আছিলোঁ। ভাড়া মাহে 1200 টকা ধাৰ্য হৈছিল। এই প্ৰতিষ্ঠান এতিয়া চলি আছে। ভাড়া মই বৰ্তমান দিয়া নাই। আমাৰ মৌখিক চুক্তি আছিল ভাড়াৰ বাবে। মোৰ ওচৰত ৰচিদ নাই, ৰচিদ দিয়া নিয়ম নাছিল। So Melody, the admitted fact in this land, he was as a tenant, he was running on the.
So how will it make any difference whether he's a tenant or not? Ultimately, we have to decide on the validity of the exhibit 2.
Yes.
Whether it can be regarded as a agreement. And whether he will have a enforceable right to for a specific performance of this agreement.
Yes, my lord.
His status as a tenant, I don't think will have much of a
No,
relevance.
my lord, regarding possession, he has stated on the very day of execution, he has had received the delivery position. So on that day, he had not taken the delivery position. Position is from earlier, my lord. It is not a correct statement, my lord. You have withheld the earlier statement, my lord. Earlier their version, my lord.
Now, how will it make a difference?
Because position, which part of he is continuing position, it is not clear, my lord. Because one is
No, he is not denying position. You said that he is in position as a tenant from earlier purpose.
Yes, my lord.
That is consistent with his stand that he is taken position. He might have been in position from before, but he is in position.
He is in position as a tenant, my lord.
The tenant cannot buy a property.
He can buy property, but he should disclose.
No, no. If he doesn't disclose, how will it be a relevant factor?
No, my lord, he has stated that on the very day he has taken possession, my lord.
No, no. We are just trying to understand. We have to see what is relevant to the issue. Whether his status was a tenant or not, that will not be relevant. His non-disclosure, will it make any difference?
My lord, the status of the area of the possession, my lord, which particular land boundary is not there, my
And
lord.
that is a different issue. Those are relevant.
Yes, ma'am. So that this non-disclosure is doubtful, my lord, and it is not specific, my lord. There is no consideration money, boundary is not there, land is not specific, it is not confirmed.
Those are definitely. Then you can say that what is there to be specifically performed? There is no contract as per it.
Yes, my lord.
Because no amount, no consideration amount
Yes,
is stipulated.
that is, my lord.
The land is not specific.
Yes, ma'am.
Even if you hold that this be a contract, can it be enforced?
No, that is the point, my lord.
And
is it hardship
is there, my lord? Even if it is 2 lakhs rupees, that is also hardship.
No, that we may not go into those, like, we are only on the legal point.
Yes,
Can you enforce this kind of a, you say it's a hand note, it's not for refund,
So, my lord, we will see.
it's not a money story, you have come for specific purpose.
Okay.
Now, even if we assume this to be a exhibit to be a contract, can it be performed? Does it have any consideration amount? Does it specify any,
It is having a consideration amount. Secondly, my lord,
where is the consideration?
my lordship will see first of all the judgment, my lord. I'm lordship, if the lordship sees the
Suppose
judgment.
I as the trial court say that yes, you have to go for specific performance decree. How much amount will you pay? Under what? Where is the stipulation?
That I will, but if the lordship sees the the judgment, my lord, para 15, my lord.
Of-
EW1 has
Of trial court,
trial court is a appellate order, my lord.
you're referring to appellate court order.
Order. And the lordship sees first of all the order of the trial court, my lord. I'm reading the order, my
Page,
page, I don't know. Trial court order.
Page started at page
page six, yes.
Page
correct.
6. The plaintiff has instituted a suit for specific performance of contract or execution of sale deed along with the permanent injunction. The plaintiff case in brief is that defendant is the owner of the land measuring 10 letters covered by Dag number 83, Kiraji Patta number 62, situated block number 4, Jorhat town, Moza, in the district of Jorhat. The defendant in need of money expressed his desire to sell the fruit land by which plaintiff consented. According to the consideration, amount was fixed at rupees 2 lakh and plaintiff on 2/4/2009 paid the entire amount of rupees 2 lakh for the suit land. The defendant executed a hand note
And
of
that part itself is inconsistent. Entire amount you are saying Agdon. Agdon is advance.
in the exhibit 2, my lord, there is not written that further amount have to be paid.
Agdon,
Other than the advance amount.
then
They understood, my lord, but this is not that subsequently you have to pay. But maybe the language, my lord, but that
we
is
are
not
going by language, we cannot impute
correct,
anything,
my lord.
any language from our own. Agdon means advance.
Then also, my lord, and one way, once the PW and cross-examination said that, my lord, that the hand note is written by him, Epilan. It is not a blank paper, my lord.
Assuming that he has written, will it amount to a contract, enforceable contract? Tell us. Where
That I will-
consideration amount is not there, the immovable property description is not there, how much land covered by what? Can you describe, can you elaborate in the plain? The foundation is the document.
Exhibit 2, my lord.
It's not a question of oral evidence, it's a question based on a particular document. Document is lacking in all respects.
Then I'll just read the judgment, my lord. Then I will.
You have the contract act, what are the essential components of a contract? The constituents of a contract? Tell us. There has to be a proposal, there has to be an acceptance,
No,
there has to
that
be a
is,
consideration.
it is,
It is not a contract.
it is on the it is on the condition that because he needs the money, man. He executed this hand note to convert into the document for transfer of the property, man.
Your suit is not for recovery of money.
No, my suit
Your
is for
suit is for specific performance.
Yes,
Additional
specific
recovery of money.
Yes.
Yes, there he has asked that you transferred his property, but he has not give the money back. That is not your suit is for specific purpose.
specific problem. Then lordship see the judgment, then I'll
Finding it difficult. Yes, tell us, let us read the judgment.
yes, the defendant in need of money expressed his desire to sell that suit land to which plaintiff consented. According to the consideration, amount was fixed at rupees 2 lakh and plaintiff on 2/4/9 paid the entire amount of 2 lakh for the suit land. The defendant executed the hand note on 8/4/2009 whereby he acknowledged the acceptance of entire consideration amount and promised to execute the sale deed soon as per provision of law. That at the time of execution of the hand note, 3 witnesses, namely Prashant Jyoti Barua, Sika Prasad and Jakir Hussain,
Ahmed were present. After payment of consideration amount, defendant immediately on 8/4/2009 handed over the peaceful past possession of the suit land to the plaintiff, and accordingly plaintiff has been continuously occupying the land without any interruption till date. Plaintiff established his garage and welding fabrication workshop from his own fund under the name style PN Saika Welding Garage over the land. That although in the contract no specific time was fixed, but defendant agreed to execute that final deed as required under provisions of law. The plaintiff was very much ready to perform his part of contract and on several times requested the defendant to do necessary formalities to execute the final sale deed. But defendant, showing various pretexts, kept postponing the execution of final sale deed and assured the plaintiff that since no time has been fixed for performance of the contract, he would definitely perform his part of contract on a suitable time as per convenience. The plaintiff in the month of September 2011 sent legal notice demanding execution of the sale deed, but the notice returned unserved. The plaintiff approached the defendant in October 2011 to obtain signature in the permission from the form of the Deputy Commissioner Jorhat and Jorhat Development Authority, to which defendant requested to wait for a couple of months. That even after repeated requests made by the plaintiff, defendant did not turn up there either to sign permission form or to execute final sale deed. Finally, the defendant used to avoid the plaintiff by not responding his phone call. The plaintiff, under compelling circumstances, as discussed above, issued notice through his lawyer Bishwajit Saikia on 23/2/2012, through which defendant claimed specific performance of the contract. The said legal notice was paid, registered, accompanied with acknowledgement card properly addressed, but mysteriously it turned unserved. Plaintiff subsequently tried to make contact with the defendant, but the conspicuously remained untraceable. The plaintiff also informed his grievance to local Mahila Samiti, who had tried to persuade the defendant and requested to execute the final sale deed. The defendant initially sought 6 months time to execute the sale deed in favor of the plaintiff. That after 6 months, that is October 2012, he informed the plaintiff that he is not going to execute the final sale deed in favor of the plaintiff in respect of the scheduled land as per the instant suit. Defendant contested the suit and filed WS, whereby he admitted to be the owner of the land described in the schedule of plaint, but denied to have executed any bond acknowledging the receipt of rupees 2 lakh. He stated the plaintiff is the tenant under him in respect of the shade and bamboo walls within presence of the land of the defendant, wherefrom he was doing his business of fabrication. It is further stated by him that plaintiff approached him for an agreement of tenancy, which inclusive of the clause in respect of receipt of rent for the previous month in lieu of issue of regular receipt for that month. Plaintiff stated to him that such an agreement is required by bank. The defendant, in response to the said request of the plaintiff, agreed to sign under bona fide belief and good faith without being expected of any ulterior design of the plaintiff. He thereafter signed on the blank piece of paper. Presently, defendant construes that the said document was fabricated and used by the plaintiff in his suit, which is referred to as hand note. It is further stated that plaintiff is in occupation of the land described in the schedule of plaintiff as tenant against payment of rent to the defendant, for which question of handing over peaceful past and vacant possession of the suit land to the plaintiff doesn't arise. That the existence of electricity connection in the name of defendant adequately substantiates the contention that presently plaintiff is in occupation in the tenanted premises as a trespasser for his default in payment of rent. Thus, the prayer was made for dismissal of the suit. After perusal of the pleadings of both the parties, the following issues of fame: whether there is cause of action for the suit, whether defendant received an amount of rupees 2 lakh from the plaintiff as consideration amount for sale of suit land, and thereafter executed a hand note of 8/4/2009 acknowledging the receipt of the money, whether the plaintiff is entitled to decree as paid for, to what reliefs the plaintiff is entitled to. The plaintiff, in support of his claim, filed evidence on affidavit, and 3 number of witnesses exhibited 6 numbers of documents, whereas the defendant filed his evidence on affidavit. Discussion, decision, and reason thereof. The issue number 1: plaintiff have averred that defendant in need of money offered to sell the suit land to the plaintiff, which was accepted by the plaintiff, and accordingly, after discussion and consideration, amount of was fixed at rupees 2 lakh. Defendant acknowledged the receipt of money by executing a hand note
in presence of witnesses. It is further averred that after payment of the consideration amount in respect of the suit land, defendant immediately handed over possession of the land to the plaintiff, although possession was delivered, but the defendant did not turn up to execute registered sale deed in favor of plaintiff, that in spite of repeated demands and issuance of the notice, defendant did not respond. Finally, he used to avoid the plaintiff. Above awareness made by the plaintiff prima facie shows that there is a cause of action for the suit. Issue number 1 thus decided in favor of the plaintiff. Issue number 2. Plaintiff PW1 has stated that defendant offered a sale of plot of land measuring 10 lochas out of land measuring 1 kata bighas 17 lochas covered by tag number 83 Kiraji Patta number 62, that he agreed to purchase the land, and accordingly rupees 2 lakhs was fixed as consideration amount, that on 8/4/2009 the entire amount was paid, which acknowledged by the defendant by executing hand note on 8/4/2009. The hand note has been exhibited as Exhibit 2. It is further stated that at the time of execution of the hand note, 3 witnesses, namely Parasjyoti Barua, Siku Prasad, and Zakir Hussain were present. During cross-examination, he submitted that initially he entered into suit land as tenant of the defendant. The rent was rupees 12,000 per month. At present, there is an institution of Messrs. Psychia Fabrication, which was established by him in the year 2008. He also stated that at present he has not been paying rent and he doesn't have to pay any rent payable, paying receipt, as defendant never used to issue receipt, and hence there was also no any condition rule issuing receipt. He denied to have obtained to the signature on the defendant fraudulently. PW2 Paresh Jyoti Barua, PW3 Mohammed Zakir Hussain, the witness to Exhibit 2 have proved the signature on Exhibit 2. They further stated that the agreement was executed in their presence, that immediately after the execution of the agreement, defendant handed over the cash possession of the land to the plaintiff. During cross-examination, evidence of PW2 and 3 remained unrebutted, whereas defendant DW1 in his evidence had denied to have offered the suit land for the sale of the plaintiff. Rather, he stated the plaintiff was a tenant and the alleged hand note was a fabricated document. It is stated that plaintiff, by misrepresenting that a tenancy agreement showing payment of rent of 1 month is required to bank for some purpose, obtained his signature in the blank paper, which was subsequently fabricated as hand note. During cross-examination, he submitted that he has not filed his evidence on affidavit oath. He further stated that plaintiff is his tenant, but there was no tenancy agreement, that he used to issue receipt on receipt of rent, but he has filed a counterpart on receipt. In this case, he admitted Exhibit 2A as his signature. He further stated that though plaintiff has obtained his signature showing reason that he would avail loan, but defendant has not inquired in the bank. He further stated that he resides in TR Fukan Road, and during March 2012 he was at home, that he could not remember if he was home from March 20 to 31. He further stated that Exhibit 6, his address, is not correctly mentioned as because Choladara has not been written. He further admitted that in his address mentioned in WS and evidence only TR Fukan Road has been mentioned. Choladara is not there. From the above materials on record, it reveals that plaintiff has proved the execution of Exhibit 2 in terms of Section 68 of Evidence Act, that apart defendant has not denied his signature in Exhibit 2, but according to him, the signature was obtained by misrepresentation, and as such, the document is not legally valid. Thus, it is seen that defendant has admitted his signature in Exhibit 2. Therefore, in terms of Section 103 and 101 and 103 of Evidence Act, the burden is on the defendant to prove that plaintiff obtained his signature fraudulently, but the defendant has failed to bring any positive evidence to substantiate his defense. That apart, cross-examination, it reveals that legal notice demanding specific performance was intentionally avoided by the defendant, as during his cross-examination he admitted that during the period when the notice was tendered by postal employee at his residential address, he was very much available at home. The above circumstances suggest the inference that case set up by the defendant is not worthy of credit. Therefore, in existence of hand note, execution of which that been duly proved by the plaintiff, I am of the considered opinion that defendant received an amount of rupees 2 lakhs from the plaintiff as consideration amount for sale of suit land, and thereafter executed hand note on 8/4/2009 acknowledging the receipt of the money. Moreover, in the incident case, defendant also failed to substantiate that plaintiff is still tenant, as admittedly there is no tenancy agreement, and he could neither produce any independent witnesses to prove the tenancy, nor has called for the rent payment received from the plaintiff to prove the subsistence of landlord-tenant relationship. During the argument, learned counsel for the defendant has stated that hand note acknowledging the receipt of money can't be considered as an agreement for sale. That apart, it is submitted that even if for the sake of argument, it is considered as an agreement for sale, also same is inadmissible in evidence, the same is not registered. The learned counsel for the plaintiff has relied upon the following decision. One, and this is then so and so the court, in order to construe the agreement, has to look substance or the essence of it rather than its form. A party can't escape the consequence of law merely by describing an agreement in a particular form, though in essence of the substance, it may be different transaction. Kamala Devi versus Tattambal and another AR 1964-59. It was held that Section 94 of the Evidence Act lays down a rule of interpretation of the language of a document when it is plain and applies accurately to existing facts. It says that evidence may be given to show that it was not meant to apply to such facts. When a court asks to interpret a document, it looks at its language. If the language is clear and unambiguous and applies accurately to existing fact, it shall accept the ordinary meaning. For the duty of the court is not to delve deep into intricacies of the human mind and assertion one's undisclosed intention, but only to take meaning of the word used by him, that is to say, his expressed intention. Sometimes when it is said that a court should look into all the circumstances to find the author's intention, it is only for the purpose of finding out whether the words apply accurately to existing facts, but in the words are clear and the context of the surrounding circumstances, the court cannot rely on them to attribute to author of an intention to contrary to the plain meaning of the words used in the document. In Nanak Builders, it was held that mere leading or title of a document cannot deprive the document of its oral nature. Law is well settled in such matters that it is the substance which has to be seen and not the form. Therefore, in the light of the aforesaid decision, I am of the considered opinion that from the plain reading of Exhibit 2, it reveals that parties to the defendant on receipt of the consideration amount had agreed to transfer the suit land, execution of the registered sale deed. That Exhibit 2, though appears to be a hand note, but from the plain reading of the document, it reveals that intention of the party is to transfer the suit land by executing sale deed following due procedure of law. Therefore, in light of the aforesaid document, I have the considered opinion that Exhibit 2 cannot be construed as an agreement for sale. That so far submission of the learned counsel regarding the non-registration of document Exhibit 2 is concerned, let me go through the relevant provision of law. As per provision of Section 49 of Registration Act 1908.
That part we are agreeing. There is no requirement for this document to register. But the document, we again come to Exhibit 2. We read it together. Do you have a copy of Exhibit 2?
Yes.
Whether it can be construed as a contract. We are have no difference of opinion that the nomenclature will not make any difference. Whether it's called a promissory note, not it make any difference. But ultimately it's the content. And the first step, trial court did not make much discussion on the, but first appellate court's discussion at page.
But I'm reading from the para, my lord.
Just a minute. Just a minute. If you come to page 30, 29. Paragraph 24.
My lordship may see para 12, my lord.
No. Come to page 29, read 23 and 24. First appellate court says.
Para 29, my lord.
No, page 29.
Page 29, para
23 and 24.
My lord.
In
In another case, CIT Punjab versus Panipat Ulan and General Mill, reported in AR 1976 Supreme Court 640, the Honorable Supreme Court has laid down that it is well settled that court, in order to constitute an agreement, has took up the substance or the essence of
And rather than its form. All
rather
right,
than
then
its
come
form.
to the discussion.
Thus, applying the opposite case laws, it is evident that in the context of Exhibit 2 that the appellant had intended to sell the suit land to the respondent. A mere variation amount about the quantum of land to be sold does not diminish the fact that the appellant had intended to sell the suit land to the respondent. It is fact that the land described in Exhibit 2 and the suit land ascertained
Appertains.
appertains to the suit dag and patta. Moreover, merely on the ground that Exhibit 2 suffers from some infirmities, technicalities, that the hand note has not been properly stamped, or that the land proposed to be sold has not been described by its boundaries, the contents of the same cannot be discarded by holding that the appellant had not intended to sell the suit land. For all these reasons, I cannot subscribe the argument of the learned senior counsel appearing on behalf of the appellant. Hence, I find that the learned trial court had rightly decided the issue number 1 and 2, all the above points determination.
But what is the consideration? Consideration is not question of infirmity. Consideration is a must. To be a valid contract, I am entering into a contract with you.
Well,
There is a meeting of mind. We should know that this is the amount we have agreed upon. There is no such amount.
If your lordship to say so,
You come to Exhibit 2, then reading Exhibit 2 will make everything clear.
Exhibit 2 is in vernacular, my lord.
Yes, vernacular, let us read. You have a copy?
I have a copy, my lord, but.
He cannot read.
My lord.
So on that ground, my lord, he cannot read Assamese middle on that ground.
No, he can read. Read it.
My lord, let me translate it, madam. I think-
No, let us read this, very important. Moishri Himan Botakur Pita, and let him.
I am reading, my lord. Moishri Himen Botakur, Pita Nam Sri Srinath Botakur, Nibah TR Pukon Road, Jorat Esa Bebohai. আজি 8/4/2009 তাৰিখে সুস্থ মগজেৰে শ্ৰী পুলকমণি শইকীয়া পিতাৰ নাম সোণাৰাম শইকীয়া নিবাস দেৱীচৰণ বৰুৱা পথ যোৰহাট পেচা ব্যৱসায়ৰ পৰা নগদ 2 লাখ টকাৰ প্ৰাপ্তি স্বীকাৰী এই ৰচিদৰ দ্বাৰা কৰিলো। এই টকা মই মোৰ মালিকী স্বত্ব থকা মেডি it is 7 নং, it is not 7 নং মিলত, it is পট্টা নম্বৰ প নং হ'ব। This should be Ponong Milat. Pata number, Bahosti number, number 46, Aru Kirasi, block number Sari, Jorat Town Mojar, Ondorgata, Ek Biga Hotolasar Mojo, King Pubdiho, Torazan Nodir Fale, Ek Pota on Ho. If Pulok Money Hoikar Bikri, Pondovaster Hongprandot, Agdon Isabe Ground Koilu, A Hangrandot, Zabotio, Ainmode Dolilazi, Oti Honkale, Mohabadan Gori Dimbuli. অঙ্গীকার কৰিলো, it is like অস্বীকাৰ কৰিলো, it is অস্বীকাৰ কৰিলো, it should be actually অঙ্গীকাৰ কৰিলো. It is the document, and land proposed land is 1 kotha melo, but their claim is 10 lakhs. Then also melo the money to 2 lakhs is not tell you the agreement melo.
2 lakhs is more or less.
20 lakhs is 1 kotha melo.
No, 2 lakhs is more or less.
2 lakhs less melo. Less melo.
That time, my lord, it is 2009, man.
Maybe.
2 lakhs is less. Less means, my lord, 2
Far
lakhs
less.
is, but 10 lakhs is 2 lakhs is absolutely okay, my lord. And that too, my lord, he's made a distress sale, my lord. Because now we can go to the quantum of the amount. And the witness is signed, my lord. And they have deposed before the court, my lord.
The witness, what of the witness said? That yes, we have signed. We, for the time being, let us overlook the defense that he had taken, that his signature was taken for some loan purpose.
That's why the, yeah.
Let us forget that. Let us not, that for a moment, let us not believe that projection. That his defense, that it was done for own purpose, let us forget. Let us treat this document as a proper document and go by its content.
Yes.
Whether this will amount to a contract.
Yes, but if your lordship says so, my lord, it will amount to a contract, my lord.
What are the essential constituents requirement for contract?
Because, my lord, see, it
Tell
is
us.
in the revenue stamp, my lord.
There has to be a promise, which means a
Yes.
proposal and an acceptance. There has to be a consideration.
Yes,
The object has to be lawful.
yes. It's lawful, my lord.
And where is the consideration?
Consideration, my lord, this amount, my lord, 2 lakh.
Agdhan.
But that is, my lord, if you see, lordship, the entire document, it is because he,
Contract. There has to be an intention, there has to be a promise, there has to be a free consent, there has to be a consideration, there has to be no legal object. If we remember correctly.
yes. What consideration and objects and lawful, what and what not.
All agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration with a lawful object and are not hereby expressly declared to you. Consideration part is not there.
Well, I'll come back tomorrow, but not tomorrow, my lord. Lordship will give me some time, my lord, because my evidence, let it be part of my lord. Lordship may fix it up on 17, my lord.
17. Forget everything.
Or my lord, on 14, my lord, on 14,
Monday.
Monday, my lord.
Try on Monday. The Decca, are you there on Monday?
Lord, I want to short ruling, my lord. I have given the list, my lord. In the, my lord, 2019 3 SCC, page 704. My lord, it is stated that it is settled principle of law that the grant of relief of specific performance is a discretionary and equitable relief. It is after, my lord, 2018, it is not equitable relief, my lord. Now it is mandatory, my lord. 2018, there is an amendment. So our case is earlier, my lord, though it is covered. The material questions which are required to be gone into for the grant of this relief of specific performance are: number one, first, whether there exists a valid and concluded contract between the parties for sale, purchase of the suit property. Second, whether the plaintiff has been ready and willing to perform his part of contract and whether he is still ready and willing to perform his part as mentioned in the contract. Third, whether the plaintiff has in fact performed his part of the contract, and if so, how and what extent and in what manner he has performed, and whether such performance was in conformity with the terms of the contract. Fourth, whether it will be equitable to grant the relief of specific performance of the plaintiff against the defendant in relation to the suit property, or it will cause any kind of hardship to the defendant, and if so, how and in what manner, and in the extent if such relief is eventually granted to the plaintiff. Then, my lord, 5. Lastly, whether the plaintiff is entitled for grant of any other alternative relief, namely refund of earnest money, etc., and if so, on what ground. They have also paid, my lord, alternative relief also. They have paid in plaintiff.
Here there is a prayer for alternative.
Yes, my lord. In the body of the plain, my lord, they have mentioned that. In prayer person, or in the alternative, pass a decree for recovery of money of amount of rupees 2 lakhs along with the interest at the rate of 80% for pending. Alternative,
Okay, when Monday next?
Monday.
Or previous record in a conflict for the petitioner, whereas here or in a conflict is representing the respondent. Read in a conflict, praise for some accommodation. Considering that this matter is of the year 2016, just on 14.
Yes.
But 53A will not come into play. Part performance will come when third party rights has got to be created. Then you can say that here it's only a question of specific performance.
Yes.
The Chaudhary, you are waiting for long, which matter?
I don't know, 12.
Today it not be possible. What is the matter for?
Testamentary appeal against order of issuance of succession certificate.
Succession certificate.
What has happened? We had also challenged their succession certificate. Therefore, there was an order in that case, CRPIO 290/2022 to take this testamentary appeal with this case. There
Here
was
is also,
a stay order also.
this is a 227 petition against the order of succession, my lord.
No, no.
227 is not maintainable.
Not maintainable, my lord.
How is 227 maintainable? It's an appellable degree.
Yes. So let it come as order is there, my lord.
We'll have it, but it's not maintainable.
My lord, there is urgency, my lord. His second wife
Okay, we'll have it.
and getting all pensionary benefits and pension now.
It is submitted that on the same subject matter, CRPIO 290/2022 is pending. Please this case along with the effort of CRP number 7 on when Friday night,
Yes,
Friday night.
much.
This was the final order in the CRP. CRP was the final order.
Final order.
Why IO then?
But by
CRP, why is IO? IO is only. for
not even
against
an
the-
exit I'll apprise.
No, IO has been introduced the 227 concept because 115 has barred interim model.
Yes, yes.
But this is not an IO. In any case, 227 is not maintainable. Appeal is there.
Yes.
Appeal is by you. Who has preferred the appeal?
My lord, there are two proceeding, my lord. One succession proceeding that was filed in Dipu, and against that, my lord, I was not implicated in that succession proceeding, and against that I have filed appeal.
And his
And I took a succession certificate at Nolbury. And that proceeding has been challenged, my lord, under Article 227, my lord.
now in your Nolbury proceeding, it has culminated or it's still pending?
Culminated, my lord. Already.
Culminated.
Yes, my lord, certificate has been issued. The problem is this, my lord, my husband settled at Dipu, my lord. And he was doing the service there. And after his death, the second wife is getting everything, my lord, compassionate appointment, everything, my lord.
Lordship, normally
And he is,
succession certificate has to be issued on from where he last resided. Lord. He last resided in Dipu. Moreover, the petitioner was informed that I am there. Still, Lordship, I was not made a party in the initial succession. Proceedings.
she is not the
And those documents are
successor,
not,
even second
those
wife.
documents are not annexed
Legally
to the
not
petition.
sustainable, my lord.
It would look like.
Much.
Deeply.